I hope you help me put pressure on the companies behind this. Let's begin.
হোস্ট কে এটা আমার ইন্ডিয়াই হোস্ট করছে
না ওই সাউথের একটা ইউনিভার্সিটি সত্যভামা ইউনিভার্সিটি
হ্যাঁ তো এটাই তো আমি বলছি
I request the participants to kindly mute yourself.
Parani, am I audible?
Yes, ma'am.
Can you please play the videos?
Yes, ma'am. Yes, ma'am. Sure. Sure.
Sathyabama Institute of Science and Technology, deemed to be University, Chennai.
Sathyabama Institute of Science and Technology, Chennai.
Sathyabama Institute of Science and Technology, deemed to be University, Chennai.
Sathyabama Institute of Science and Technology, Chennai.
Sathyabama Institute of Science and Technology, deemed to be University, Chennai.
University established. Welcome to Sathyabama Institute of Science and Technology, deemed to be university, established in the year 1987 under the leadership of our founder Chancellor, Colonel Dr. J.P.R. Sir. Presently, the institution is governed by the Chancellor, Dr. Maria Zena Johnson Ma'am, and President Dr. Mary Johnson Sir. The School of Law of Sathyabama University is established in the year 2018, headed by the Dean, Professor Dr. Dilshad Sheikh. The Sathyabama School of Law aspires to be an internationally renowned center for research and teaching in law. School of Law is dedicated in advancing human dignity, social welfare and justice through knowledge of law. Our School of Law offers BA LLB Honours, BCom LLB Honours, BBA LLB Honours and LLB programs. The courses are academically rigorous, informed by the latest research. The School of Law comprises of highly dedicated, efficient and industrious faculties who have published their research papers in various national and international journals, and also invites a cadre of intellects that includes respected judges and experienced practitioners. School of Law work with a wide variety of group including the legal profession, policy makers, research bodies and organizations, and this reflects our strength in many fields of legal and social legal research and gives our students the opportunity to interact with internationally respected scholars. The curriculum has been designed to provide with a strong foundation in the core subjects coupled with opportunities to pursue optional courses in the areas of undergraduates' choosing. Every classroom in School of Law is equipped with smart classroom facilities with high-speed internet access. Feasible forms of lectures with updated versions of law is value added to the students to keep them updated in the fast-moving society. The School of Law also comprises a well-furnished moot court hall named after our founder Chancellor Colonel Dr. J.P.R. The School of Law have also successfully organized Colonel Dr. J.P.R. Memorial Moot Court First All India Moot Court competitions, wherein law students from across the country participated. The School of Law also owns an exclusive law library which comprises of about 4,000 updated books and also has a set of AIR manual and electronic version of AIR criminal law journals. The law library also has a set of Indian Bar Review, selected judgments, and professional ethics published by the Bar Council. The School of Law also hosts and encourages students to organize many academic events such as national and international conferences, lecture series, symposiums, seminars, and workshops with industrial professionals and judiciary experts to equip themselves with leadership skills and enhance their ability and their knowledge for their future career. The Law Department also hosts regular and periodic faculty development programs on recent trends and developments in the areas of law to develop the faculty members in the legal fraternity. The School of Law also organizes several legal awareness camps in various villages in and around Chennai in order to spread legal awareness among the downtrodden societies. At the outset, School of Law provides an ideal learning environment as it sets a perfect blend of professionalism and culture in the legal studies. Wholeheartedly, we welcome you all to the School of Law of Sathyabama Institute of Science and Technology, deemed to be university. For further details, visit www.sathyabama.ac.in. Thank you.
Sathyabama Institute of Science and Technology, deemed to be university, Chennai.
Is also known as The city of Mohenjo-daro was located in the banks of the ancient city of Mohenjo-daro was located in the banks of
Ishwa. Okay, for the kind information of the participants, the session is about to commence sharply by 4 o'clock.
Mrs. Pujasri, kindly check. It seems guest has already joined.
Yes, ma'am. Yes,
Yeah. Kindly check. There is a query from the guest like the program will commence at what time.
Ma'am, Invavijayan sir will be joining with us in few minutes, ma'am.
Okay. Since there is a query from Christopher sir, kindly check whether sir has joined and he had an inquiry like are we starting in 15 minutes? Yeah.
Yes, ma'am. Mr. Christopher To. Mr. Christopher To, am I audible? Ma'am, sir will be joining in another 2 minutes, couple of minutes, ma'am. Like, we'll just start sharply by 4 o'clock, ma'am.
Right.
Yes, ma'am.
Usually it seems Inbavijayan sir joined, ma.
Good evening, ma'am.
Sir, good evening, sir. How are you, sir?
Fine.
Thanks for joining. Good evening, Mr. Christopher, and welcome to the international seminar. Thanks for joining.
Okay, thank you for inviting.
Thank you.
Good evening, sir. Ma'am, all set ready, ma'am. Shall we start?
Yes, it's 4 o'clock. Correct.
Yes, ma'am.
Please proceed.
Over
Can
to
we-
you, Rani.
Yes, ma'am. Thank you, ma'am. The secret of getting ahead is getting started, says Mark Twain. A very good evening to everyone present here. With the blessings of our founder chancellor, Colonel Dr. J.P.R. Sir, and the Almighty, I, on behalf of School of Law, Sathyabama Institute of Science and Technology, deem it an extreme privilege in welcoming the chief guests, our participants from various esteemed institutions, and each one of you to the international seminar on emerging trends on mediation and arbitration in association with the Kovise Foundation Conflict Resolution International. For the kind attention of the participants, I request all the participants to mute yourself so that the event could be hassle-free. In order to receive the e-certificates, the participants are requested to fill in the feedback form, which will be provided at the end of the last session. I repeat, for the kind attention of the participants, the feedback link will be provided at the end of the last session.
The sun enlightens everyone, but the light of knowledge enlightens those who are actively seeking the light. I now humbly request Dr. Dilsad Sheikh, our Dean, School of Law, Sathyabama Institute of Science and Technology, to deliver the welcome address.
Thank you, Mr. Ishwa. With the blessings of our founder chancellor, Colonel Dr. J.P.R., architects of Sathyabama, most respected Madam Chancellor, Dr. Maria Zina Johnson, our President, Dr. Mary Johnson, our mentor, Madam Vice Chancellor, Dr. T. Shasiprabha, Pro-Vice Chancellors, Registrar, Controller of Examinations, Director Administration, Dean Student Affairs, Dynamic Resource Persons, national and international delegates, participants, and ladies and gentlemen. Good evening to you all, and warm greetings on behalf of School of Law, Sathyabama Institute of Science and Technology, deemed to be university. It gives me immense pleasure to welcome you all to today's international seminar on emerging trends in mediation and arbitration. We have a rich program with many distinguished speakers. I truly think that this seminar would not have been possible without the seamless cooperation and staunch support from our ever-encouraging management, and I would like to take this opportunity to express my heartfelt gratitude to Mr. V.Inbavijayan Veeraraghavan, founder and project advisor, Kfcri, founder of Kovise Global LLP, the organizer with us. We thank you, sir, and immensely happy to get collaborated with Kovise. Distinguished guest, Dr. Christopher To, FCIR, CIR, Chairman of the Hong Kong Institute of Directors. Sir, I am honored to welcome you, sir, and I am very grateful to you for giving time from your busy schedule. I extend my hearty welcome to Mr. Ramesh Selvaraj, Co-Deputy Head of the International Arbitration Practice, Recruitment Partner of Allen and Gledhill LLP. I extend my warm welcome to the distinguished guest, Mr. Ben Giaretta, Partner and Co-Head of International Arbitration at Fox Williams LLP, Chartered Arbitrator. It is a pleasure and privilege to welcome Mr. Muthupandi Ganesan, LLM, FCI, ARB, and Barrister at Law in England and Wales. It gives me immense pleasure to welcome Ms. Rekha Rangachari, Executive Director of the New York International Arbitration Center, and Dr. Kabir Dugal Arbitrator, Attorney in the New York office of Arnold and Porter, Lecturer in Law at Columbia Law School. I am thankful to all the speakers for consenting to share the knowledge at the seminar, and we thank you for your very kind gesture of acceptance in spite of your manifold preoccupations. Thank you all. And it is an honor for us to welcome representatives from our knowledge partner organization, academics, as well as experts from law and industry. We once again express our own sincere appreciation to KFCRI. With their support, we can move forward, and we are grateful to Kovise Foundation for their contribution in organizing this seminar in association with our organization. Once again, I welcome you all, and as Dean School of Law and convener of the International Seminar, I would like to officially announce the opening of the International Seminar on Emerging Trends in Mediation and Arbitration. I very much hope that you will enjoy your time here with us and explore the knowledge on mediation and arbitration. Thank you all. I welcome you all.
Thank you, ma'am. I now request the student coordinator, Ms. Sariyu, from first year BLLB Honors, to introduce our knowledge partner, Mr. Inbavijayan Veeraraghavan, founder and project advisor, KFCRI, and founder of Cove Global LLP. Over to you, Sarayu.
Thank you. I take immense pleasure in introducing Mr. V.Inbavijayan Veeraraghavan sir, advocate cum international arbitrator and mediator director. Mr. V.Inbavijayan sir was educated at Dr. Ambedkar Government Law College, University of Madras. On completion of his legal education, he took up litigation practice at High Court of Madras in 1997. Sir's enthusiasm towards ADR made him to pursue whole-time arbitration since 2001. So far, Sir has presided as sole arbitrator and presented as counsel in over 350 domestic cases, several thousands of small claims, commercial or financial arbitrations, and more than 15 international commercial arbitrations. Sir's area of practice includes international commercial arbitration, maritime arbitration, international trade and contracts, IPR, construction disputes, finance and banking disputes, securities market, JVs, LRCs, ADR, sale of goods, domain name disputes, and investment disputes. Sir has been accredited as an arbitrator in India, Hong Kong, China, Malaysia, Egypt, and various other regional and national arbitration institutions. To add up, Sir is a co-founder and former secretary of an arbitration institution, CNICA, and inducted as a member of ICCA. Sir is a regional pathway leader for international and domestic arbitration, construction, education, and mediation courses, course director and fully approved tutor of Chartered Institute of Arbitrators, UK, and had been listed in the 2008 edition of International WHO's Commercial Arbitrator. To add up, Chambers Asia Directory in 2010 refers to Sir as Inbavijayan Veeraraghavan, is active in commercial arbitration and described as excellent and handles matters in a highly professional manner and can achieve fast results. Sir undertakes both domestic and international arbitration, particularly in international trade and commercial disputes. In addition, Sir is promoting the concept of ADR by the way of writing articles and books, providing training courses, and gives lecture on arbitration and ADR in law schools, universities, chambers of commerce, and conferences worldwide. Hearty welcome to you, sir. I humbly request Mr. Inbavijayan Veeraraghavan sir to deliver the felicitation address.
Thank you. Thank you, Sariyu. Good evening, good morning, and good afternoon to all. It is always a privilege to join hands with an esteemed institution like Sathyabama University School of Law. And this is another occasion that too after signing the Memorandum of Understanding a day before our Independence Day, that is 14th August, we had a great occasion signing the MOU with the School of Law. Coming to the theme, I am very happy that all of my well-wishers and good friends, starting from Mr. Christopher To, even though it's quite late in Hong Kong, he has consented to just join with us and share his view on very particularly on the mediation concept. And one interesting thing, Mr. Christopher To is already in our advisory board, and he is guiding us very actively in promoting the concept of ADR, at least in this part of the world. I am very happy to thank other colleagues, Mr. Ramesh Selvaraj from Singapore, Mr. Muthupandi Ganesan, a close friend, and you can say as a part of family. I am very happy to welcome Mr. Muthupandi Ganesan. I am keen to hear from all these practitioners, particularly having the Asian background. And I'm also keen to know about this Med-Arb concept, the hybrid concept from Mr. Ramesh Selvaraj, as well as Mr. Muthupandi Ganesan. To add on, it is always a privilege to have other good friends, particularly from the Chartered Institute of Arbitrators, the London branch chair, Mr. Ben, and interestingly, the New York International Arbitration Center Executive Director, Mrs. Rekha Rangachari, as well as Dr. Kabir Dugal. And Kabir Dugal is a member, a fellow of Kfcri also. With these introduction, I wanted to thank the organizers, particularly the Sathyabama School of Law, giving this great opportunity within a short time period. That is very important. And I have to thank particularly my Kfcri team members who are here. I could see many faces, happy faces, who are going to organize as well as moderate all these sessions. Finally, as a felicitation, I want to thank the speakers, the eminent speakers, who are going to deliver the most important concept of Med-Arb, a combination of mediation and arbitration. Even though this Singapore Convention on Mediation is going to take the major share out of the New York Convention, I feel that personally that it will be a balancing act, whether this mediation or arbitration would have a good competition and is going to complement to the society, wherein the litigants would enjoy this dispute resolution process, and ultimately practitioners and ADR professionals are going to deliver the harmonious part of the society. Thank you.
Thank you, sir. I now kindly request Mr. Shanmugadev, Managing Committee, Kfcri, to introduce of Kovise Foundation Conflict Resolution International.
Thank you, Ishwa, for giving me this good opportunity to speak about my institution, that is Kfcri. So, before giving a brief intro about Kfcri, I should start with its mother body, that is Kovise Foundation. So, Kovise Foundation is a non-profit organization. We got established in the year 2014. And from then, we are running with multiple projects and few of institutions. And to be more precise, one such institution is Kfcri, that is Kovise Foundation Conflict Resolution International. So to speak more about the functions of Kfcri, we function in three predominant roles. And one is an institution. As Kfcri as an institution, we have our own rules for all the area mechanisms such as arbitration, mediation, negotiation, even for the role of tribunal secretary. So which means that any individual or any individual entity can adopt the area as an institution role in their own area process or in the area mechanisms, whatever it can be in arbitration or mediation. The other big role is as an accreditation body. The objective of the foundation in itself is promoting and disseminating knowledge for the professionals in the very diversified fields. In that way, we train professionals in the area of field and for the sustainable development of this area whole process. Another role as a think tank. The Kfcri currently, to be more speak over the history of Kfcri, are conducting so much events in the role of think tank. And when I say event, it also includes so much trainings and other programs such as mediation competition, or it can be an essay competition. And one such precise moment is with this School of Law Sathyabama Institute of Technology. We are here for this international webinar with the diversified resource person of Kfcri around the globe. So I must definitely be proud to say that Kfcri is one of the fast growing institutions globally. And I extend my heartiest welcome to all the attendees and my resource person of Kfcri as panelist on behalf of the entire Kfcri team and all the attendees. I extend my most welcome. Thank you all.
Thank you, sir. I take immense pleasure in welcoming Ms. Pooja C., Research Associate from Kfcri, to introduce our first speaker, Dr. Christopher To, Chairman of Hong Kong Institute of Directors. Over to you, Ms. Pooja.
Thank you. First of all, I would like to thank Dr. V.Inbavijayan, sir, the whole Kfcri team and School of Law Sathyabama Institute of Science and Technology for giving me an amazing opportunity to handle and moderate this session in the presence of globally accredited arbitrator Dr. Christopher To, who is an experienced arbitrator, adjudicator, and mediator, having handled a variety of international disputes ranging from investments to technology. He is an FCIR CR chairman of Hong Kong Institute of Directors, past chairman of CIR, and also an advisory board member of Kfcri. Sir, it is an honor to moderate this session with you, and we warmly welcome you, sir. Commencing today's session on the topic of virtual mediation. Virtual mediation is a process by which parties can settle their disputes online without the need for in-person appearances. Apart from the pandemic, the virtual mediation has been emerged and played a significant role and had a success percentage of 85% around the globe. I would like to pass on the session to Dr. Christopher To explore various dimensions about virtual mediation. Over to you, sir.
Okay, thank you very much. Thank you, the university and also KFCRI for inviting me to actually this seminar. And I apologize for coming in a bit late because I was rushing from my business in Hong Kong because it's now late at night in Hong Kong. Now, I've always started, how should I say this? I always had a passion for arbitration from day one. And when I joined the Hong Kong International Arbitration Center as Secretary General, I always had this passion of arbitration. But in the last 15 to 20 years, I think that I've got to the stage whereby some disputes don't really warrant going through arbitration. And I found that now using mediation to resolve disputes, I find it sometimes very effective. And the key thing about it is parties' relationships are maintained. Now, when people talk about online, I started the Asian Domain Name Dispute Resolution Center in Hong Kong. And when we started the online domain name dispute resolutions, everyone thought that no way, no one's going to talk about online. Everyone thinks it's too futuristic, Christopher. You're basically dreaming. But now you see, we are now in a seminar. Everything's all done online. So you can see that the future's here. The technology will basically one day take over in terms of dispute resolution. Now, not necessarily the personnel, okay, but at least, for example, in terms of how we conduct hearings and also the meetings as well as sessions for mediation. Now, I've done quite a few mediations online. What do the parties feel about mediation online? At first, the parties feel that, for example, is it really safe? Is my communication, whatever I say online, going to be disclosed to the whole world? Is someone going to record what I say and publish that in some kind of social media? The other thing is, what about document sharing? Some documents, they believe that it should not be shared online because it could create problems whereby people are stealing your documents. That's another issue. And once you get through the hurdle about confidentiality, the issue about security, the next issue comes up about in terms of the bandwidth of your computer. So sometimes we have to switch off the screen so you can't see your face because in order to save on bandwidth. So you can see that there are lots of hurdles to actually get moving with online or virtual mediation. Now, once you get used to it, I had a client who actually got used to it after doing 2 or 3 sessions with me, suddenly said to me, maybe in future, we just do things online. It's much easier. And one thing about we're using Zoom now is in terms of interpretation. So if you buy the professional or the more expensive as of a module for the Zoom, you can actually allow for interpretations, whereby, for example, an interpreter can speak to you and your microphone, your headset and so forth, and you can understand what they're saying and without actually being interrupted by the witness in terms of saying certain things. So in a way, it's very effective. Now, in terms of mediation, now most people believe that you need to actually see people's demeanor. You need to see their facial expressions. You need to see whether they're lying, whether they're sweating, whether they're moving their hands left to right, and so forth. But in saying that, if people are sincere about committing themselves to resolve the disputes, whether you are in person or online, the chances are they are going to be committed. It's just a matter of convincing them. The technology is there to facilitate it. It's not there to overtake what you're about to say to the mediator. Now, one of the aspects that I find very good in terms of virtual mediation is what happens is the mediator can record the session. Now, most people say that you have to talk about reality testing, doubt creation, getting to know people's understanding about their underlying issues, whether they've repeated a word over and over again. For a mediator, basically with this recording session that you can control as a mediator, sometimes if you miss something, you can understand what they're saying, you can play it back and actually understand what they were saying so that when you come to them and do a caucus again, you won't be actually feel out of the way. Now, in saying that recording, the mediator does have a duty, once they finish the mediation, whether you settle or not, to erase the recording. Because if you set up the Zoom meeting, the chances are you have the ability to record. So the parties do not have the ability to record, but sometimes I tell them don't use your iPhone or your mobile device to record because we do have a law in Hong Kong whereby mediation is supposed to be confidential. Now, that is basically some of the drawbacks in terms of some people raised about mediation doing online. But the good thing, as I mentioned, one of them is recording. The other good thing about it is you don't really have to have the people waiting in the room while you are discussing the matter with someone else. In the virtual one, they can actually be at home. And it works because I did a case last week involving a client from Toronto, another client from mainland China, and I'm based in Hong Kong. So you can imagine the time differences. So the time differences are sort of basically morning and night. Okay, so in a way, we're doing mediations in the morning, say, for example, starting at 7 to cater for the ones in Canada, and we finish at 11 during morning time. Then we come back again at night time, and we start at 7 and we finish at 11 at night to cater for example, Canada and also Beijing. So you can see that is this issue about you have to travel, you have to get everyone into one room and all that. I don't think it really basically matters anymore because people are now used to doing things online. Now, there is an issue. People will say that, oh, once the COVID-19 goes away, we will go back to our old habits of actually traveling and asking people to come and meet. The answer is, I would say yes. Why? Because we're all locked in our houses, universities, in our domains, the chance that we do need to go out and meet people face to face. So I think that once we have this lockdown released, people will start to actually interact more. And this online thing might die down a bit. But if there's a die-hard group of people like the young university students here who are keen on this area, you can actually build a business in terms of creating software, creating a platform so that professionals like us can actually use a platform that's tailor-made to conduct dispute resolution. Now in Hong Kong, the Hong Kong government is currently developing a platform to cater for online arbitration and online mediation. But it's nothing new, okay? We're using it in Zoom. So the chances are you just need to refine it in terms of the confidentiality aspects. How do you make sure that it's confidential? How do you have the protocols in place to ensure that there's no recording and so forth? And also whatever is discussed in the session is basically confined to those in the session without someone coming in to listen to what you've got to say. Now, I personally believe that virtual sort of is a good thing, simply because it's difficult for people to travel sometimes. Okay, people with disabilities, they can't travel, they have to get around as well. So if you do basically have virtual systems in place which cater for that, actually it creates a sense that we care about others as well. Now, going back to why I think virtual mediation will take off. Because parties don't want to now see people face to face when they have a dispute. Every time when they see them, they basically start to shout and scream at them. And if you look at the court systems in various jurisdictions, including India and all that, we have a backlog. If we have a system whereby you can work at night times, day times, and you don't need to travel and all that, and you can resolve the matters quicker, the chances are that is access to justice. So I believe that this online virtual platform could reduce the backlog in the court systems by encouraging people to go to mediation. And also people don't have to travel. Now, as most people believe that mediation is developing. We do have the Singapore Mediation Convention, whereby enforcement of mediation settlement agreements. But we also have, for example, legislation in Hong Kong that has mediation, and other jurisdictions as well that has legislation and mediation. So the chances are, give it time. This animal, mediation, called the sleeping dog of the past, I don't think it will be the sleeping dog of the past. I think it will come up barking, and people will say that, I don't want to take 2 years to resolve my dispute going through arbitration. I want it resolved within this year. I want to resolve next month so I can get on with my life. So mediation has that element of actually speeding things along, getting to that party's interest without getting them into a situation whereby they have to spend umpteen amount of money in terms of the process. Now, most of the young graduates who come out from your law school will say that I need to make a living. I can't basically just rely on very cheap ways of doing a dispute resolution by mediation. I sometimes need to have a long case of 1 to 2 years so I can survive and all that. Yes, but in saying that, if you do good mediation, what will happen is word of mouth. People come back and ask you to do more, just like today. As I was logging onto this system here,
Doctor, I'm very sorry for interrupting. You have to unmute, doctor. I'm sorry.
sorry.
Thank you.
Sorry about that. So one thing good about mediation is basically if you do a good job, people will recognize you. And some cases are warranted to go to arbitration, but some cases are mediation. So, but I believe that if the small end, the low end disputes can be resolved by mediation effectively, the chances are you're doing a good service to the community. And on this note, I really hope virtual mediation will really take off this time rather than wait another 20 years. So on that note, unless you have any further questions you want to ask me, I think I've given you some background about why I have a passion towards mediation.
So thank you for your words. Thank you for enlightening us with virtual mediation. And I would like to post a question.
Yep.
In offline mediation, there will be a face-to-face encounter which reinstates faith and trust upon the parties. How significantly this impacts the ability to successfully carry out the process in virtual mediation?
I think it all boils down to preparation. You have to, based on the pre-mediation with one of the parties, explain to them the process, how the tools of this virtual mediation works, and convince them that basically everything is going to be okay. And you have to do that. And once they've tried the system a few times, they get to know it better, and they ask you lots of these questions they have underneath their sort of their thoughts. Then the chances are they are more open. Now, once you get them to use it, doesn't mean straight away they're going to be trusting the system. You really have to make sure that they really trust it by engaging them more, by asking them to speak and asking them to tell us more. And so you can see, for example, by engaging them on the virtual system, they suddenly become trusted to the system. And what will happen is they will open up more. And even some cases whereby, for example, they might be wearing their night clothes to come to the mediation, which in my case, I did in Vancouver, Toronto. One of the parties was wearing his pajamas when he was doing the mediation. Okay?
Yes, sir. Yes, sir. Thank you, sir. Thank you for insightful and enlightening speech and giving us your knowledge, sir. And as you dealt with many views on mediation, how it will be handled and what are the advantages of virtual mediation and what will be the scenario after COVID-19. It was a great speech, and your knowledge was enlightening us with much of thoughtfulness and contemplating. So on behalf of Sathyabama, School of Law, Sathyabama Institute of Science and Technology, and Kfcri, I take this opportunity to propose and extend my gratitude to thank Dr. Christopher To for enriching us with your knowledge on the various aspects of virtual mediation. We are really enlightened with your knowledge and presence, sir. I would like to thank KFCRI and School of Law, Sathyabama Institute of Science and Technology for organizing a wonderful session. A heartfelt thanks to our students for active participation and cooperation. With these warm words and a kind message, we move on to the end of the session. Thank you.
Thank you.
Thank you, sir.
Thank you, Ms. Pooja. Now, I call upon Mr. Rishi Kannan from BBA LLP on his third year for the introduction of Mr. Ramesh Selvaraj, Co-Deputy Head of International Arbitration Practice, Recruitment Partner at Allen and Glidden LLP.
Thank you, Shwab. Good evening to all the fervid partakers, eminences, and the key speakers out here sharing space in this virtual platform. As Lord Alfred Tennyson observes, knowledge comes, but wisdom lingers. It's indeed a prerogative of mine. Rather, I feel gleeful to welcome the second speaker of the day, Mr. Ramesh Selvaraj, co-founder of the International Arbitration Practice. Sir is an alumni of National University of Singapore. Sir is a recruitment partner at Allen and Glidden LLP. Sir is also a co-chair of the YSIAC committee. He is also a principal mediator of the Singapore Mediation Center. Today, Sir is going to be extravagant with us in sharing his boundless knowledge on the emerging topic of the rise of hybrid dispute mechanisms. Over to you, Sir.
Thank you, Rishi, for the very warm welcome. Let me first begin by saying that it's always a pleasure for me to be back in India. This time virtually. It's always a pleasure. My roots are actually from India. My great-grandparents actually left India many years ago to move to Singapore in search of greener pastures. Singapore has now become home, but India is really the country of my roots. So naturally, it gives me great pleasure to be here with all of you today. So I thank all of you for having me. I did want to start by apologizing for not having any PowerPoint slides, but I was very heartened to see that Dr. Christopher To, when he started his presentation earlier, he spoke from the heart and from his experience and didn't use any slides. That's heartening. It's not something that I'm particularly keen on myself. So for those of you that prefer presentations by slides, this isn't going to be one of those presentations. I'm just going to be speaking from the heart, sharing my experience on this particular topic and knowledge that I've gained over the years. And I think it will be a fruitful session if there are questions posed after I present it. I very much welcome questions, and hopefully we will have some after I've finished my short presentation. When you heard from Dr. To earlier, I think he was speaking about the benefits of mediation, and I think he spoke about it in the context of virtual mediation. Now, I'm going to be touching on mediation somewhat, but in the context of hybrid or sometimes called tiered dispute resolution clauses. Now, before we go into talking about hybrid dispute resolution clauses, I think it will be useful if we start looking at what a standard dispute resolution clause is to begin with. Now, most of you or some of you may know, dispute resolution clause is a clause that you see typically in an agreement between parties, contract between parties. And in that particular clause, you will find a forum set out in which parties want their disputes arising out of that agreement or contract to be resolved. So typically you might find in a standard dispute resolution clause a provision for jurisdiction of a particular national court or national courts to resolve disputes. Or alternatively, you might have a clause providing for arbitration as the way of resolving disputes. You will find in that sort of a dispute resolution clause an arbitral institution that is selected, arbitral rules to govern the arbitration, the number of arbitrators to preside over the arbitration as well. You'll find these sort of things in a typical arbitration or dispute resolution clause, where there's reference to one type of dispute resolution. Now, when you come to talking about hybrid or tiered dispute resolution clauses, what this refers to is different layers to the dispute resolution process. So this often tends to be a combination or sometimes what we call a mixing of the modes of dispute resolution. Often mixing between what we call adjudicative methods or modes, which tend to be arbitration or litigation, and non-adjudicative modes, which would largely be negotiation, mediation, and the like. Often for hybrid dispute resolution clauses, you often will see a mix between mediation and arbitration typically. Mediation, Dr. To spoke about it in depth earlier. I'm not going to go into what mediation is all about, but broadly, you may have gathered or understood from what you had heard earlier. Mediation is where you see voluntary negotiations facilitated by a neutral party, known as a mediator, which may result in a contractually binding settlement. In its classic form, mediation as well, the mediator typically does not express any views or an opinion on the merits of the case, on the facts, on the law. His role is really one of a facilitator, and his idea, or rather his mandate, is to try to get parties moving forward, getting parties closer to one another, helping parties to arrive at a satisfactory solution, a win-win solution for the parties. And often the focus is on commercial business solutions. So that's really the nub of what mediation is. Now, arbitration, again, in summary, I'd like to call it private judging. That really is a case where you appoint someone, a third party, to serve as an arbitrator, a judge, a private judge, to adjudicate disputes. I must apologize for my pet dog that is barking in the background. So arbitration, as I said, is what we call a private judge, typically appointed by the parties, and if no agreement is reached by the parties, an arbitral institution that appoints an arbitrator, an adjudicator, to decide the dispute between the parties. He then arrives at a judgment. In the arbitration context, we refer to it as an award, which is binding upon parties as such. So, as I said, hybrid dispute resolution clauses in the main tend to mix these two types of dispute resolution mechanisms, mediation and arbitration. It would be useful to broadly understand what each of that covers. Now, these type of clauses allow for a claim to be escalated in stages. What I'm going to be doing in a short while is talking to you generally about more common types of hybrid resolution clauses, but we're still now talking about these clauses in a general sense. So as I was saying, these type of clauses actually allow a claim or a dispute to be escalated in stages, right? So for instance, you could have a clause which makes reference to negotiation, mediation, as well as either litigation or arbitration, and it's dealt with in stages. So it may be that the clause talks about negotiations at different levels within each party's business organization. And then if there is no resolution that is reached at that stage, You then go on to the next stage of mediation. And even if at that stage you don't arrive at a resolution, you may then go on to litigation or arbitration as a final means of resolving the disputes between the parties. So that's to give you a flavor and an understanding as to how these clauses might operate in practice, and escalation of how the process might be undertaken between the parties. Now, what I can share is that in recent times, there have been global surveys that have been undertaken involving major companies, major corporates, Fortune 500 companies around the world about dispute resolution mechanisms and processes that are out there. And the result of these surveys is actually quite resounding in that many respondents have opined to say that they found that the most effective type of commercial dispute resolution involves combining both adjudicative and non-adjudicative methods. So there's a real sense that when you mix and match these type of dispute resolution processes, it makes and calls for a more effective way of resolving disputes. So I think these type of clauses, the trend is that they are on the rise. I do believe that they are here to stay. There is a big push towards alternative ways, of quicker, more cost-effective ways of resolving disputes. And I do think that these type of clauses actually lend support to that. So the takeaway, I do believe, is that across the globe, when you're dealing with litigants, there appears to be a general consensus that the way forward is for mixed mode dispute resolution. And as I mentioned, these processes are thought to be cost effective and also are believed to help preserve relationships between parties as such. You have a non-adjudicative method as perhaps stage 1, stage 2, there's an increased chance of a resolution being reached whilst a business relationship still being preserved between the parties as such. So you can immediately appreciate why there is a draw towards these type of clauses. Now, the one, for me personally, the one advantage I do see in these type of hybrid clauses is that it actually puts ADR on the agenda for the parties on the table early on. Now, what do I mean by that? You will find that often when you do not have such clauses, and if you had a standard clause in a dispute resolution clause in a contract, say providing for litigation or arbitration, when a party chooses to broach the topic of mediation in that sort of a context, that often tends to be perceived by the other party as a sign of weakness of some sort. So as I said, you've got a clause providing for litigation in the Indian courts or say the Singapore courts. If one party is then early on in the proceedings choosing to propose mediation, the worry is that that might not be perceived well, in that the other party might regard you as sensing some weakness in your case as such. Now with hybrid clauses, because the non-adjudicative methods and modes are already worked into the clause, it's on the table for the parties as such. So there's no fear. In fact, it is for the parties to necessarily comply with the stages as they escalate the matter. And there is no perception of weakness either way as such. So I do think that there is some real benefit to be gained in that regard when you're dealing with these clauses. Now, I think I've broadly spoken about what these clauses are and cover. I think it will be useful for the attendees for me to briefly touch on certain more common type of clauses that may interest you. Now, the one that is that has been traditionally quite prevalent and common is what we call Med-Arb clauses, mediation arbitration clauses. Now, again, it's no big shake. It's fairly easily understood. The name is self-explanatory in itself. What this entails is parties actually having resort to mediation in the first instance. And if mediation doesn't bear fruit in that no binding settlement is reached between the parties, you then go on to arbitration in the next stage, where the arbitrator then decides the matter and issues an award as such. Now, there's some variations for how this is undertaken in practice. It may be that the party that plays the mediator is also the same party that plays the role as arbitrator. It may be that the parties are different, meaning you have a mediation before one particular mediator, and then if that fails, you then commence an arbitration before a separate arbitrator as such. Now, there are pros and cons to both, but increasingly, you'll find that the trend is for this process to be undertaken by separate parties, meaning you have one mediator, and then that same individual does not serve as arbitrator if this matter goes on as such. And the reason for that is that there's a perception that somehow if the mediator also wears another hat as an arbitrator in the second stage, there's some risk that the arbitrator's impartiality may have somehow been affected or compromised. And this in itself may risk some challenges to the eventual award that may be issued in arbitration and so on. So you'll find that this type of mediation arbitration clause is common, but we're seeing more often that it is the case that two different parties actually play the role of mediator and arbitrator as such. In a scenario where you have the same party playing the role of mediator and arbitrator, I talked about how there may be perceptions as to a lack of impartiality and bias and so on. Now, one other complication that has arisen in that sort of a scenario is this. Now, what happens in that scenario is if a mediation is successful, the mediator may well then wear another hat as arbitrator and record parties' settlement as a consent award between the parties, which may then sought to be enforced between the parties. There's a school of thought and there's some issue that has been raised as to whether or not such an award is even enforceable to begin with at law. And we're talking about a consent award that has been arrived at pursuant or further to a mediation as such. Now, the issue there is under the New York Convention, as some of you may know, there's a requirement for there to actually be a dispute between the parties before an arbitration is commenced and an award rendered. Now, there's a school of thought that says if a mediation has already arrived at a binding settlement as such, or settlement as such between the parties, then it raises questions as to whether or not when the arbitration was commenced, there is even a dispute to begin with as such. So these are things that parties have been alive to and has shaped how this process has evolved in recent times. So that's one process I wanted to speak to you about. What I will go on to talk about next is the flip side of this. So we spoke about Med-Arb. Now this is now Arb-Med. So it's the flip side of what we were speaking about. Arb-Med clauses, as you can imagine, clauses where the substantive arbitration hearing takes place in the first instance. Now what's unique is this. In this sort of a setting, the arbitration award may well have been prepared, but it is sealed and not issued to the parties. The arbitrator then wears a separate hat to become a mediator to try and facilitate a settlement between the parties. And if there's a failure in that regard to reach or arrive at a settlement, the award then may come to be finalized and issued by the arbitrator. This sort of method is not particularly common, I must say. It is used in certain limited contexts in certain jurisdictions around the world. And it is also not thought to be a particularly cost-effective method because, as you can imagine, what happens in the first instance is you go through the full arbitration hearing substantively before you then go on to the second stage of mediation as such. So not particularly cost-effective, but what's interesting is that studies and surveys that have been conducted or studying this particular type of hybrid clause and mechanism have actually curiously found this particular method to be quite effective. And I do believe that the reason why this appears to be somewhat effective is that the uncertainty over the outcome of the award appears to motivate negotiations between the parties. And I suppose that there is a sense that the arbitrator, who is now wearing a different hat, wearing the hat of a mediator, when he's facilitating, may be, in a sense, leading parties to arrive at a resolution with the award and the decision that he had arrived at sealed, no doubt. So the somewhat uncertainty over the outcome has been found to motivate and negotiation outcomes and favorable outcomes in the second stage as such. So that's all I have wanted to say about this particular stage and phase. Suffice for me to say that, again, that this particular type of resolution mechanism is not as common as the one I had spoken about earlier, Med-Arb. Finally, I wanted to speak about arbitration, mediation arbitration. We call this AMA, that's Arb Med-Arb. This appears to be the most common type of hybrid resolution clause that we see in recent times. Again, not the name is self-explanatory. You are now actually talking about arbitration having been commenced and a mediation phase intervening before progressing onwards to I suppose, the more substantive part of the arbitration. Again, it really is up to the parties. Often it is the case that the party serving as the mediator is different from the party playing the role of arbitrator. It may well be that the party is the same as well. But in this type of hybrid resolution clause, you do not have the issues that I had cited earlier for Med-Arb. You recall I had said Med-Arb, when you have a resolution in mediation, you then try to record it as a consent award. It raises questions as to whether or not there was even a dispute between the parties at the time of commencing the arbitration. Now that does not arise in this particular setting because this is an arbitration that is commenced first off before you progress on to mediation as such. So if you've got a mediation arrived at and there's a resolution as such, parties can then go back before the arbitrator having conduct of the matter and is presiding over the dispute to record the terms as a consent award as such. And the Untitled model law actually recognizes these sort of consent awards, and you should have no difficulty seeking to enforce such awards across the world largely. So that's what I wanted to say about the what I do believe to be one of the more common hybrid resolution clauses. I'm mindful of the time as well. I just wanted to wrap up and say that increasingly you find these type of clauses being included in various contracts that are negotiated between the parties. The point though to note is that these type of clauses, particularly dispute resolution clauses, are often relegated to what we call boilerplate clauses. A lot of the substantive clauses are negotiated in detail, but dispute resolution clauses are often overlooked as such. So I did want to sort of end off by saying that unclear drafting can actually lead to serious and often unintended consequences later on, if and when a dispute rears its head. There may be ambiguities, and those ambiguities in the way these clauses are drafted may in itself lead to satellite litigation in future. Satellite litigation, I mean examples like challenges to the jurisdiction of a tribunal, challenges at the enforcement stage when an award is issued. So those things in itself may be time consuming and add a significant layer of costs as such. So clarity in drafting these clauses is essential. Do pay heed to these things. It may be that when you come out into practice that you are asked to advise on the drafting of these type of clauses, or opine on the enforceability of clauses that have already been drafted. And so it will be useful for you to bear these things in mind as such. So I'm mindful of the time. I do believe I think I have overshot my time somewhat, but I do hope that the material I've shared is of some use to all of you. Thank you.
Thank you so much, sir. That was a limpid lecture from you, sir. So we have a few sort of questions. So with your permission, let me read the questions, sir.
Sure.
There is one question from our participant, Mr. Krishna Rao. Will acceptance of parties in mediation are binding as admitted acceptances in arbitration?
The question is, will acceptance of parties in mediation are binding as admitted acceptances in arbitration? So not sure exactly what the question is driving at, but I'm guessing it refers to whether or not the outcome in a mediation is binding between the parties. So perhaps I'll answer the question by saying as follows. Now, mediation, as we know, is consensual, is a voluntary process. Unlike arbitration, where the arbitrator decides your fate, mediation, it is a party-driven process. So the parties actually decide on the terms of a settlement. If parties actually decide on terms and are agreeable to those terms, then those terms may well be binding between the parties. What happens is, if you have that sort of in-principle agreement between the parties, that may then be recorded as a consent award between the parties, such that it is binding between the parties. But as you recall, my dear friend Mr. V.Inbavijayan earlier, when he spoke about the Mediation Convention and the Singapore Convention on Mediation, increasingly you're going to find that around the world, with the Mediation Convention actually gaining in force and acceptance by various state countries, a mediation agreement by itself may well be binding upon the parties. The whole idea behind the convention is to give recognition to mediated settlement agreements and allow them to be enforced, almost like judgments, orders of court as such. So if you have a settlement agreement that is signed off between the parties, then they will be binding whether or not you record them as a consent award in arbitration.
Thank you, sir. There's another question from one of our participant. Which is more advantageous, whether it is Med-Arb or Arbit?
Okay, so again, there is no direct answer to that question. As I said, do not look at these clauses as standard or boilerplate clauses and pick them for use. It really is the case that you need to configure your hybrid resolution or dispute resolution clause, configure a process to fit the substance in question or the issues in question, taking heed of the type of parties that are engaged in the process. So at the time of negotiation of the underlying contract, this is a clause that you should be paying attention to. And then you need to decide on the facts and on the circumstances at hand, which is preferred as such. I don't think anyone can say that one type is more advantageous than the other. If you study each of these types of resolution clauses, you will find that almost all of them have their own pros and cons. It really is finding and settling on one which you think is properly configured to suit your needs in your particular case as such.
So there's one final question, sir. Do hybrid dispute resolution clauses survive termination?
Do these dispute resolution clauses survive termination of the contract, the underlying contract?
Yes, sir.
I think the answer to that is yes. And that is often why you even have arbitrations that are commenced, for instance. You have a contract that is terminated, there's an issue over wrongful termination of that particular contract, and you then necessarily invoke those provisions dispute resolution provisions to determine and deal with that particular issue as such.
Thank you so much, sir. That's it, sir. Over to you, Ishwa.
Thanks a lot, sir. That was a truly enlightening session. And thank you so much, sir, for patiently answering all the queries. Thank you, sir.
Always a pleasure.
Yes, sir. I now invite the student coordinator, Mr. Rohan, from first year BLLB Honors to render the vote of thanks. Over to you, Mr. Rohan.
Thank you, Bhagwati. Ladies and gentlemen, a very merry evening to all of you. I would love to begin by thanking all of you for taking the time listening to me. Today, we are graced by the presence of our most valued Honorable Chief Guest, Mr. Ramesh Selvaraj, Co-Deputy Head of the International Arbitration Practice, Co-Chair of the YSIAC Committee, and also Principal Mediator, Singapore Mediation Center. I cherish this day and take immense pleasure in thanking you for taking precious time out of your busy schedule while being patient throughout the session and for answering the questions as well. It was truly enlightening to know about the rise of hybrid dispute mechanism, Med-Arb and Arbmed. I would like to conclude with the words of Albert Schweitzer. At times, our own light goes out and is rekindled by a spark from another person. Each of us has cause to think, and with deep gratitude for those who have lightened the flame within us. I don't think there isn't one person amongst us who would disagree when I say that the ambers were lit. Your words have indeed inspired us and will always do. It's my privilege to propose the vote of thanks. I feel proud to acknowledge the contribution of those who worked really hard to make this international conference happen to be a great memorable occasion. Thank you and have a great evening ahead.
Thank you, Mr. Rohan. I take immense pleasure in inviting Mr. Kavin, Research Associate from Kfcri, to introduce our next speaker, Mr. Muthupandi Ganesan, Barrister at Law at England and Wales. Over to you, Mr. Kavin.
Thank you, Harani. It's my privilege once again to moderate Mr. Muthupandi Ganesan, who is today's keynote speaker on the topic of practitioner dealing with hybrid process. Mr. Muthupandi Ganesan was a qualified lawyer both in UK and India. He was admitted to practice as a barrister at law in England and Wales and a qualified advocate in India. He was a member of Worshipful Company of Arbitrators and a member of a Society of Mediators in London. Not only in ADR, as Mr. Muthupandi Ganesan specialized in the field of anti-bribery, anti-corruption, bankruptcy, and insolvency, etc. At present, he was a barrister and partner at Alliant Law in UK, as well as advocate and partner at Ganesan and Manuraj Legal LLP in India. My hearty and warm welcome to Mr. Muthupandi Ganesan for the session.
Kevin, I hope you can all hear me. Good morning and good afternoon to you from London, wherever you are. Thank you so much for the invitation, first of all, to Sathyabama University, and of course to Mr. V.Inbavijayan and Kfcri, and of course a pleasure to be here. And it's been a privilege to listen to Dr. To and of course Mr. Selvaraj as well. So thank you, and I'm looking forward to it. And it's a very interesting and enlightening event so far.
Thank you, sir. Thank you, sir. It's our pleasure too, sir. And moving on to the interactive session, my first question to you, sir, Mr. Muthupandi Ganesan, sir. In the current world, the hybrid clause in the nature of Mediator has been the sought after dispute resolution mode, as it generally believed to enhance resolution of disputes. According to you, sir, as ADR practitioner, what are your views on it, and why is the most recognized hybrid model?
Thank you, Kevin, for that. Just to simplify the question, I suppose the basic is, why, as Mr. Selvaraj has been talking about the hybrid models, and why particularly that this current Med-Arb, that's mediation followed by arbitration, is actually a quite not only interesting, but from a client perspective, an important one. And I think I've been given the task of, I know that a number of other practitioner attendees and on the panel as well, but certainly from my practice and from my dealing with client end of it and being as counsel in matters, there's a lot of attractive elements to a Med-Arb. And I think first of all, from a client perspective, what do most commercial clients want to deal with in terms of dispute? They want to deal with it quickly and as cheaply or as cost effective as possible. And I think that's where the real attraction comes into it from Med-Arb point of view. It has the ability to have the mediation as the initial stage if all that fails to an arbitration. I think as our earlier speaker, Mr. Selvaraj, was saying, that the key to the success of Med-Arb and to the effectiveness of it is the ability for the parties to be able to actually say, well, I don't want to wait next 2 years or 3 years to go through a arbitration agreement and have very detailed legal arguments on what does a contractual clause mean, what are the terms, and arguments on seat of arbitration, arguments on the interpretive clause between maybe 2 or 3 different jurisdictions. All of that can be put aside. From a client perspective, they can actually focus on the real issue. We have a dispute, and often in many arbitration contracts, the scope of dispute itself is a dispute. And often that's what you will find many lawyers arguing over months as to whether in fact the dispute itself is a dispute that needs to be arbitrated. So when you look at arbitration, and before that, if you have a mediation as a form, it has real flexibility to it. It allows to put aside all that legal nuances and legal contractual arguments that lawyers love arguing about, but clients don't. Clients want result. Client wants resolution of their problem. And I think that's where Med-Arb is really a useful tool, whereby the initial mediation can really cut through the red tape in the sense of proceedings and the procedures and what goes on, and really try and narrow down and focus the parties on what is the real issue, leave aside legal nuances. Now, I think that's the flexibility is a key aspect of mediation. And I think, as Mr. Selvaraj touched upon, when you have a facilitated mediation or facilitative mediation, where you are really as a mediator, an arbitrator who may be sitting as a mediator, and we can talk about that in a bit, but certainly if you have a neutral who's focused purely on getting parties to actually consider the issues, focus on the dispute at hand and how to resolve it, rather than all the other procedural legal aspects. I think that is something very important, certainly from a practitioner's point of view. It's very important to a client, because what you're doing, you're cutting through all the layers of problems and procedures you normally deal with as an arbitration mechanism, whereas you're going straight into the meat of the dispute. So in terms of flexibility is important. Of course, by getting through the nub of the matter quickly, you're also saving huge amount of cost. And I think that, again, is an important aspect from a client's perspective. And the third thing, and certainly this is what I find, often you have clients, when you're sitting in a mediation setting, whether it's physical or on an online, clients are much more focused on achieving a result, and they have a lot more incentive, lot more willingness, and a lot more engagement than you get, for example, if it's a straightforward arbitration where parties file their responses, file their evidence, file their documents, and wait for that, final hearing. So I think flexibility, cost, engagement of the parties are the real positives of having a clause that allows you to have a mediation as the initial stage. I hope that answers your question. I'm sorry, I taken a
Yes, sir, definitely, sir. Thank you so much, sir. It will be really an eye-opener, sir, for the practitioners as well as. Moving on to the second question, sir. Mr. Muthupandi Ganesan, it isn't a victory unless enforcement of settlement take place, which become binding between the parties. In the lines of same, can you tell us how will the hybrid Med-Arb clause will function, and what is the enforcement regime that is involved in order to make the settlement binding?
So if I understand it, it's really the question as to how do you actually deal with the final piece of whether it's the mediation then turning into an arbitration and having an arbitration award. If I may, I'll break that into two parts, and I think just giving a general information to all the students and other practitioners, who may be listening on this and watching it. Really, there's two parts to it. If it's arbitration, we're all very familiar with the way arbitration awards can be enforced, particularly under the New York Convention, which is a well-recognized model with long-established legal principle on applicability, recognition, and enforceability. So there's no issue with that. As long as you have an arbitration award, I think most countries will enforce it. And of course, we even now have new countries joining in every year. Most recent one, I know only because I've been dealing with a arbitration case involving Seychelles. Seychelles ratified New York Convention in February 2020, and it came into force in April or May 2020. So that is a living instrument which an arbitration award can be utilized to be recognized in more than 150 countries across the globe. Now, the more interesting and I think more exciting developments is in relation to how the international legal scenario is developing with regards to the enforcement of mediation agreements. What I mean by that is the settlements that have reached through mediation. And of course, we all will be familiar with the UN Convention on International Settlements Agreements resulting from mediation, or most often is easily referred to as the Singapore Convention on Mediation. And that is extremely important event that happened last year when it was came into being, and that was on the 7th of August 2019. And of course, it's now in force as of 12th of September 2020. And certainly when I last looked it up, we have had about 53 countries that have signed up to that Convention on Mediation. And we are looking at other countries joining as days and months go by. So I really think that this mediation and mediation agreements, whether it is as part of a hybrid mechanism like Med-Arb, or whether it's an individual sole mediation agreement between the parties as a consent or an agreed form, I think it's exciting that we can now actually enforce it, and particularly enforce it through the Singapore Convention on Mediation is a really a powerful tool. And that's the tool that I really hope, as Dr. To said earlier, mediation is seen as a sleeping dog. Well, in my view, and I agree with Dr. To, it is going to be one of the more exciting and more interesting and more powerful ways to resolve business disputes across the globe using these mediation agreements and mediation, and not to use the word award, but certainly mediation results between the parties, which can then be enforced in different countries.
Thank you, sir. Thank you so much, sir. Mr. Muthupandi Ganesan, most often in a Med-Arb mechanism, the parties involved in dispute never unveil the exact grievance as it might determine a binding award. What can a practitioner do in order to negate the same while restoring confidence with the parties to bring out the necessary information?
Thank you, Kevin. I think just to rephrase that, you're asking about how do practitioners in real life able to give that confidence to clients so that whether it's the Med-Arb type dispute resolution clause or any other means, whether it's just a pure mediation itself, where the parties and particularly clients are willing to engage and to actually focus on the issues at hand. Certainly, from my experience, it's been really interesting, this pandemic, this coronavirus effect on mediation has been. And I have been on recently 2 or 3 online mediations, and I'm glad to say they have all successfully settled in that sense. But it's been a very different experience to a physical mediation that I've been used to for many years, where in a physical mediation you would have been separate rooms, you would have the neutral or the mediator going from one room to the other room and able to take information back and forward. But interestingly, in those sort of physical hearings, you would be able to sit with your client and be able to discuss and talk and go through, particularly in difficult hearings, where either it's emotive or persons involved are in an emotive state, and those are quite hard. But interestingly, as Dr. To was referring early on to online mediation is actually quite powerful in the way that people are able to feel, and especially via the Zoom mediation, where you could have waiting rooms, you could have your own private sessions with your client online. Of course, with many mediations, it's hard because it has got practical issues of staring at a computer screen for 8 hours and talking to your clients who are sitting in different part of the world with different time zones and other practical problems like internet connections, power failures and things like that. But leaving all that aside, I certainly found in my practice this online mediation in cases where there's Med-Arb clauses actually in place and active, we were able to get the clients by focusing on trying to resolve the dispute rather than by going through the legal processes and maneuvers that you would normally do with an arbitration hearing. And I think certainly from the clients and the business disputes that I have been involved in, where clients' primary focus, particularly now, is in the times of uncertainty with coronavirus and so on, is really try and resolve the dispute rather than have a long-term, 18 months, 2 years down the track process where you then would actually have to then follow that with enforcement proceedings. So I think it's a question of understanding the type of dispute you're involved with, understanding the type of clients that you're involved with, and then having a common sense, practical approach in making them understand, even though you may have a neutral who may, in a Med-Arb type scenario, would initially be a mediator followed by an arbitrator. It's for that clients to understand the quality of the mediator, the ethics of the mediator, so that they know the person that's appointed is experienced, is able to deal with these type of cases in a professional, on a non-conflicting manner. And I think that's one of the issues with Med-Arb. How can a neutral be a mediator first, then he can be an arbitrator afterwards? So I think it's building that confidence into clients and making the clients understand. And certainly in the cases that I've been involved in, clients have been sensible, clients have understood the issues at hand, and often the cases I've been involved in had large financial elements to it, so people were more than willing to actually try and find a way to resolve the disputes.
Thank you, sir. Thank you for sharing your knowledge, sir. It's an extremely pleasure to hear us, sir. Moving on to the next question, sir. ADR is vastly known for its transparency along with impartiality. In the view of the same, can you tell us how will an active mediator shall also act as an arbitrator in hybrid Med-Arb dispute? Will the practice of the same hinder the essence of ADR, sir?
That's a really interesting question, Kevin. Thank you for that. And I think it goes to something that I have certainly I've spoken before about. It falls into really the category of ethics of a neutral, whether you're an arbitrator, whether you're a mediator, and how do you deal with that? And I think certainly in practice, it goes to what I was saying a little bit early on. It's if you have an experienced neutral, whether they practice as a mediator or an arbitrator, I think experienced practicing professionals understand the difference between a facilitated mediation as opposed to a hard-fought legal and legally difficult and complex issue being resolved by way of an arbitration. And I think most practicing experienced barristers take their duties and roles very seriously, especially in the context of Med-Arb, where they know how far their duties lies in terms of working as a facilitative mediator, as opposed to later on, if the initial mediation fails, then coming along to the actual arbitration and dealing with the arbitral process in a proper procedural manner, whether it's the ICC arbitration, whether it's an ad hoc arbitration, whether it's SIAC arbitration, whatever it might be, is following within those rules. And if you have a experienced arbitrator and a mediator, I don't see problems with that. But of course, I'm alive to that. Many people do have problems with that. And many people say, well, how can a neutral and a mediator who's been privy to some information that must automatically make him biased or make her biased in the second stage of the process? And I can see the arguments in relation to that. And of course, I can also see the perception of clients in relation to that. But certainly in my experience, I have had people who are perfectly able to deal with that logistical maneuver, both as a mediator and as an arbitrator. But more importantly is that legal maneuver is putting aside information that is either irrelevant or inappropriate in consideration if the mediation fails, and then you move on to the arbitration. Certainly in our practice in London, I'm sure Ben Giaretta may comment on in due course. Certainly in our jurisdiction, judges are able to make determination often on certain preliminary issues, and they would then put that aside when it comes to consideration of the substantive issues. So yes, transparency is important in mediation and arbitration, but of course mediation is and arbitration are led by the parties. And I think it really goes down to the arbitrator or a mediator or the neutral you choose and their experience. And of course, they will be bound, whether they're acting in a mediation capacity or in the arbitration, they'll be bound very strictly to the ethics of an arbitrator or as a mediator.
Thank you, sir. Thank you so much for enlightening, sir. And last question, sir, final question. In a global scenario, as we move towards an renewed environment of dispute resolution, according to you, what will be the impact of Med-Arb hybrid process in the near future, sir?
Thank you, Kevin. I think certainly in my view and in the cases that I have done, Med-Arb is a very, very popular in terms of the alternative dispute resolution mechanism, because people do appreciate going to either the national court or arbitration proceedings can be exceptionally expensive, time-consuming, costly in terms of both time and money. But more importantly, often it's that the enforcement that becomes a key issue in different countries where different rules of recognition enforcement applies. So I really think from the future point of view, I see mediation as the real valuable mechanisms that parties will adopt. And I particularly see online mediation as being an extremely valuable and an attractive tool, not only to clients, but also to legal practitioners across the globe. And I see Med-Arb as being a very popular, and I think we may see that a lot more in contracts. And I think with the coming into force of Singapore Mediation and Convention, I can see a lot more of the contracts, particularly government contracts in different parts of the world, will be more willing to use this sort of Med-Arb clause to deal with the disputes quickly and effectively.
Thank you, sir. It's very informative. The interaction is very informative, sir. Moving on to the Q&A session, sir. Question from Mr. Rashid Jashit or right. What is your take on witness credibility and evidence in whole in virtual ADR?
Thank you. That's an interesting question. Yes, it depends on the nature of the witness that's giving evidence. You, of course, have factual witnesses where, as Dr. To was earlier mentioning, a lot of people talk about, well, in virtual hearings, you lose out on their demeanor, you lose out on their manner, you lose out on the things, the body languages that we are used to seeing in a physical hearing. But often, and certainly in many of the cases that I've been involved in, the factual disputes tend to be very small parts of it, whereas the bigger and more important element tends to be the evidence that's either given by an expert witness, for example, or a lot of evidence is given in relation to legal disputes. So I don't see a huge amount of difficulty in having witness evidence being given by online hearings. And I've been, in the last few months, been involved in 4 or 5 live witness evidence being given in both factual and legal evidence. And it has worked perfectly well. And there hasn't been a case where I have said, on a business dispute, we're not talking about family cases, or we're not talking about criminal cases, or we're not talking about cases where real emotive evidence is being given. On a pure business disputes, we've been able to deal with that quite well on online hearings.
Yes, sir. Sure, sir. Thank you, sir. And moving on to second question, sir. ADR does in other to strict evidence rule, unlike typical litigation proceeding, won't this cause an innocent in certain case to be convicted?
Sorry, Kevin, I didn't.
Sorry.
Would you mind
ADR,
repeating?
yes, sure, sir. ADR doesn't other to strict evidence rule, unlike typical litigation proceeding. Won't this cause the innocent in certain case to be convicted?
Maybe I have misunderstood that. I think that may be that may be going towards a criminal cases. I think that may be looking at that sort of scenarios. As you know, most countries don't allow arbitration of criminal proceedings, and so that may not quite fit within what we've been talking about here, which is the Med-Arb clauses on a business disputes. But if the concern is about, are there going to be injustice, or are there going to be findings of an arbitrator that's going to be inconsistent or wrong or unfair because of the online hearings? In my view, as I said earlier, that can all be overcome, particularly when you have representations for parties involved in commercial disputes.
Yes, sir. Thank you, sir. Thank you so much, sir. A question from Ramarao. What is the success ratio between mediation and arbitration between two which is empathic?
I don't have any statistics on the success rate between mediation or arbitration. There are plenty of online surveys that have been done, and for example, when Singapore Convention on Mediation came into force, there's a number of different working groups that were set up by the UN who looked at various different statistics. Those are all available publicly. I don't have any particular figures on that, but certainly from my experience, and certainly in the last sort of 6 months of doing many online hearings, I can say with some confidence, most of the cases have settled on mediation, and there are no issues in relation to that.
Thank you, sir. Thank you so much, sir. The way in which Mr. Muthupandi Ganesan conveyed the answer to the queries for the participants was really an eye-opener, sir. I hope this session was really an informative one. Thanks for sharing your knowledge on practice area. It will be really helpful for the ADR practitioners as well as budding ADR learners, sir. It's my pleasure to moderate this session, sir. My hearty thanks to Mr. Inbavijayan, our mentor, Kfcri team, as well as School of Law, Sathyabama Institute of Science and Technology for giving me this wonderful opportunity.
Thank you so much to everyone.
Thank you. Now, I call upon Mr. Karthik, Research Associate, Kfcri, to introduce Mr. Giaretta, Partner and Co-Head of International Arbitration of Fox Williams LLP, Chartered Arbitrator.
Thank you, Ishwa. Before we could jump into the sports session today, I would like to give a brief introduction about our panelist now. He is a counsel, arbitrator, and mediator specializing in international dispute resolution. He has extensive experience in the resolution of international disputes across many sectors, including energy, construction, engineering, infrastructure, shipping, telecoms, mergers and acquisitions, and insurance. He has worked on disputes in many different countries across Europe, United States of America, Africa, and the Asia Pacific region as well. He is currently based in London as a partner and co-head of international arbitration at Fox Williams LLP. Sir, it's an absolute pleasure to have you with us today. And having learned from the previous speakers as to what a hybrid clause and how it works exactly, I would like to invite Mr. Giaretta to enlighten us on what arbitration can learn from mediation and vice versa. Over to you, sir.
Thank you very much, and it's a pleasure to be here. I'm very pleased to have been invited to speak to you today. So my topic is not really about mediation arbitration, it's about comparing mediation and arbitration. And in particular, as I've said, as has been said, the title of this talk is what arbitration can learn from mediation, what mediation can learn from arbitration. And I think it's vital for us all to think more about the relationship between mediation and arbitration, the ways in which they interact and the ways in which they can be combined. We need to think holistically rather than categorizing certain disputes as suitable for arbitration and certain disputes as suitable for mediation. Disputes change over time. People change over time in their attitudes to a dispute and their motives for pursuing it. We need to bring a flexibility to our thinking about what is the best way in which the dispute can be resolved. Equally, we need to be flexible in our thinking about different dispute resolution methods. No method is perfect. Each one could be improved. I would say it's not healthy for lawyers to categorize themselves as arbitration lawyers or litigation lawyers or mediation lawyers or whatever. They need to recognize the strengths and weaknesses of each method and think about how they can improve their practices and their services for their clients. And this includes comparing and contrasting each dispute resolution method. I'm going to draw such a contrast here, in particular to think about what arbitration can learn from mediation and what mediation can learn from arbitration. Now let's first think about what arbitration has become. While arbitration started out as a process that had relatively few rules, it has become more rule-bound. The recent revisions of the LCIA rules and the ICC rules, for example, have added to the lengths of those documents. Now, by highlighting this, I don't mean to imply a criticism of the rules themselves. The increasing lengths of rules can be for a number of reasons. It might reflect the many customary practices that have grown up in arbitration. That is, all that has been done is to convert an inviolable practice into a black and white rule, meaning that there's no net change overall. Also, it seems that all systems tend towards complexity over time. And it shouldn't be surprising that as arbitration has become more international and has been used in more disputes, that there should be more rules to cope with all the different situations that have arisen. But there's a risk here. The more we focus on rules, the more we think about ways around them. That's the natural tendency of game playing humans. If there's a rule about when a document must be filed, we think about how that deadline can be extended. If there's a rule about what evidence is to be filed, we think about how that can be used as a way to embarrass the other side and cast doubt on its position if it doesn't meet the required standard at the first time we're asking. The more we think about rules, the less we think about more important things. Above all, the less we think about the outcome of the dispute. We focus on the battle, not on the war. The result is that costs and time go up relative to the value that clients derive from the process. So what about mediation? One of the great positives of mediation is that when it's done well, is that it challenges parties to think about what they really want out of the dispute resolution process. What is their true aim, bearing in mind the cost of the process? Consequently, what can they settle for? Do they want a payment at all, or is there something else that they would be happy with? Mediation is outcomes focused. Now, perhaps there's a negative here as well. Sometimes I feel the parties don't devote sufficient attention to the mediation process, with the result that they may approach the possible outcomes from the wrong angle. And sometimes they need to sit down with the other party and hear what the other party has to say, even if it is critical of them. Sometimes you need that pain to earn that gain. But overall, there's an important lesson here for arbitration. If one focuses on the outcome in an arbitration, then the process can be kept on track. Of course, different parties to arbitrations have different outcomes in mind. Each will want their own side to win, but an outcome-focused approach will still help. Issues that are extraneous can be stripped away. Applications that serve no real purpose other than to score cheap points can be dispensed with. The process overall can become more efficient in the sense that each dollar and each hour spent delivers real value rather than being mere fat on the bone. Now, terms of reference sometimes receive criticism from some quarters, but I'm a fan, not when those terms of reference just involve the parties going through the motions when drawing up the document in an unthinking manner, but when the parties apply their minds to what the real outcomes of the arbitration process should be and how those outcomes might be achieved. And when they constantly return to the terms of reference throughout the arbitration to check that they are still on track, or to ask whether the dispute has changed so much as to require a different direction. In a mediation, the mediator is the process manager who's constantly exhorting the parties to keep their eyes on the prize, to keep aiming for a successful outcome. In arbitration, perhaps one of the tribunal members, the presiding arbitrator most likely, could be tasked with constantly returning to the terms of reference and asking whether the arbitration is still on course to achieve the outcomes the parties set out for themselves at the start. Or perhaps with the increasing prevalence of tribunal secretaries, this could be one of their responsibilities. They could be the party's motivator and the lawyer's conscience, reminding the parties to remain engaged throughout the arbitration and encouraging the lawyers to recognize at every point what is in the client's best interest. In ancient Rome, when a general rode in a chariot through the city at the head of his army in triumphal procession, a slave stood behind him, holding a laurel crown, and continuously whispered in his ear, "Memento mori," remember you are mortal, so that the general would maintain his sense of proportion. Similarly, the tribunal secretary could metaphorically whisper in the parties' and the lawyers' ears, remember what you're here for, so that they can keep things in proportion. Let's think of, that's what arbitration can learn from mediation. Let's think about what mediation can learn from arbitration. The evolution of international arbitration across the world has led to the creation and adoption of an increasing number of tools and techniques for the administration of arbitration. This has been in response to feedback from users of arbitration about the faults of the process. It has also been the result of highly intelligent and experienced individuals applying their minds to the question of how arbitration can be improved. Many of these tools have now become so familiar that they have their own capitalized names: the Redfern Schedule, the Kaplan Opening, the Reed Retreat, and others. Arbitration practitioners have learned how to look at their processes and critically evaluate them, then produce innovative solutions. Now, personally, I think that more can be done in this respect in arbitration. There's room for even more improvement. I also think that the increasing use of technology, such as the online platforms now being promoted by arbitral institutions, will drive even further discussion of what are the best techniques in order that they can be encoded into the systems. But my purpose here is to not just discuss how arbitration can be improved, rather to consider how the journey that arbitration has been on in the past 30 years can be a learning point for mediation as it looks to the future. What can mediation learn here from arbitration? I suggest a greater use could be made in mediation of the various tools and techniques that have been developed in arbitration, or versions of these tools and techniques which are adapted for mediation. There may be, for example, a schedule setting out all the issues in the case. There could be another schedule setting out, for the mediator's eyes only, the various settlement options that a party might consider. It could be a decision tree diagram identifying the courses of action open to a party, bearing in mind the options available. There could be a standard schedule with the estimates of costs up to the end of the arbitration or litigation. There could be a mind map identifying all the relevant interests of a party. Now, none of this is particularly new, and I'm aware that much of it already features in the toolkit of a mediator, but it's not usually part of the toolkit of the parties to a mediation. And if there are specific terms for such tools and techniques, they can become part of the language of mediation. They'll be what the parties expect to encounter in a mediation. And preparing such documents will help put the parties in the right frame of mind. Magicians often prime their audience for a trick that comes late in their performance. They may emphasize certain words in their stage patter, or highlight certain concepts in pictures on screen in order to plant thoughts in the subconscious of the audience that will influence their reactions to a trick at the climax of a show. You can also think of one of the classic studies by Robert Cialdini, who's a famous professor in America. And he ran an experiment about the behavior of visitors to a petrified forest in Arizona. On some days, signs were put up, phrased positively: "Please leave the petrified wood in the park." And most visitors have left the petrified wood in the park, preserving the natural state of the forest. On other days, signs are put up phrased negatively: "Please don't remove the petrified wood from the park." And many visitors have removed the petrified wood from the park, changing the natural state of the forest. And when the negative signs were on display, 4 times as much petrified wood was taken from the forest compared to when the positive signs were on display. The visitors were primed to take the wood rather than leave it. Similarly, mediators could prime the parties by setting them certain tasks and thereby prepare them to approach the mediation positively rather than negatively. At present, in many mediations, parties are asked to draft position papers in advance. Now that focuses the parties' minds on the issues that divide them. It might be better if they were asked instead, before they attend the mediation, to prepare documents that focus them on the common ground and on the possible ways forward towards a settlement. This may create a change of mindset for the parties that will smooth the path towards a settlement. In suggesting this, I'm conscious of what I've said in the first part of this talk, that when faced with rules and requirements, parties will incline towards point scoring. And no one would want such tools and techniques to add to the time and cost of mediation, or to turn a flexible process in something that is almost as rule-bound as an arbitration. But if the parties understand that the products are mainly or exclusively for the mediator's eyes only, and may avoid too much game playing, and the potential negatives should be weighed up against the advantage of getting the parties in the right frame of mind at the start of the arbitration. On balance, I think the benefits would outweigh the disadvantages. Finally, how can we apply this to the main topic for today's seminar, which is mediation arbitration? Adapting arbitration and mediation this way would mean that every stage of the dispute process would be outcome focused, and that the best tools and techniques can be deployed, which would prepare the parties at an early stage for what is to come. The result should be a dispute resolution process that remains on track. It would also be made lean with extraneous elements removed. Of course, maybe some parties' inclination to exacerbate and complicate will work against this, but in the hands of the right mediator arbitrator, these changes could transform mediation arbitration for the better, just as they might transform mediation and arbitration individually. Thank you very much.
Thank you so much, sir. It was wonderfully put, the relationship between the arbitration and mediation. Sir, I personally have one question. Do you think what mediation can learn from arbitration is to have a governing or a statutory body to govern mediation? For example, in India, we have a statutory act named Arbitration Conciliation Act governing over the arbitration proceedings, whereas the same for mediation is absent. So do you think it will be better, or do you think the mediation can learn that from arbitration?
Well, probably not is the answer, because certainly the experience of arbitration is that you have laws about arbitration, and you need laws about arbitration. I'm not denying that, but the experience has been that you'll end up with litigation about arbitration. You'll end up with parties going off to court and arguing about how the arbitration has been run, whether the arbitrator has been properly appointed, whether there has been compliance with the rules or whatever. Now, if you had a similar law about mediation, you would probably end up with a similar amount of litigation. And that's not really in anyone's interest. That said, there is a positive in having a legal framework to arbitration, which is obviously to supervise what's going on, but also to give it authority, to give it an international reach, to give it an awareness in people's minds. And I can see actually with the Singapore Convention on mediation, we may end up with more and more mediation laws around the world, and we may end up with litigation about mediation. And that may well bring some benefits, although I am hesitant to support it. I do suspect that it will end up with perhaps far more trouble than it's worth.
Thank you so much. Thank you for the insight. Now, I would like to hand it over to the host for the further session.
Mr. Karthik, if you're done, can I ask one question?
Yeah, sure.
Yeah, Mr. Ben, it is a great pleasure to have you here. I just have one question, since we have so much of young practitioners and students here, and your topic is more related to what mediation can learn from arbitration and what arbitration can learn from mediation. Just one question for the benefit of all. What are the qualities or the skills young practitioners, the students should develop, especially to become a good arbitrator or mediator, or it could be the process of both, this mediation, the Med-Arb. Can you please just highlight on that, please?
Well, there are some qualities for an arbitrator and a mediator which are in common, and there's some which are different. both a good mediator and a good arbitrator need to be good listeners and good readers of human behavior. I was once told that a good advocate likes to talk and a good arbitrator likes to listen. I think it's very important when you are involved in any form of dispute resolution, actually, as the decider of the case or as the mediator, that you really listen to what people are telling you. It's very easy in life to only half listen to what people are saying, or to project your own prejudices, bias, thoughts onto what they're saying, and then not properly understand what's being said. So if anyone wants to be a full-time arbitrator or mediator, I'd encourage them first to consider whether they are good listeners and how they can improve their listening skills. The second quality that they both need, I believe, is a quality of organizational, administrative skills. So we're talking about slightly different types of administration, but both arbitrators and mediators need to be able to keep the show on the road. They need to be able to move things forward. And in many ways, if you look at the job of an arbitrator, the job of an arbitrator is as a process manager all the way up to the writing of the award. When it switches to being the job of writing an award, it becomes like the job of an author or writing a book at that point. But it's very definitely there's very definitely an important part of being an arbitrator, just as there is of being a mediator, of being the process manager. What about different qualities between an arbitrator and a mediator? Now, an arbitrator, and this is a very obvious point, and forgive me perhaps for making it, an arbitrator needs to decide. Fundamentally, the job of the arbitrator is to decide. And decision points come at various times during an arbitration. Most obviously at the end of the arbitration, but also early on when there are applications being made about a whole range of things in terms of the process, in terms of interim relief, in terms of et cetera. And they need to be able to decide fairly and decisively. That's to decide decisively. That should be obvious. But sometimes decisions are not made in a very clear manner, and that doesn't help. You need to be able to reach a fair and clear decision on things, and that quality is not needed by mediators, of course, because they don't have to decide anything. But on the other hand, mediators, in my experience, very often have to have the skill of persuasion in a good way. I mean, a mediator has to, if you like, gently persuade parties, or stand behind them and gently steer them in a particular direction. Now, very obviously, a mediation is not about a mediator telling the parties what to do, and that's obviously what it's not about. And it's the parties' decision about what is the right thing for them, and whether they should settle at all, and what the settlement should be if they want to settle. But a mediator very often helpfully can guide them in particular ways of thinking about things. They can help to bring out certain points. They can help to change people's emotions about particular topics. And that skill of gentle persuasion, if I could put it that way, is something that a mediator needs and an arbitrator doesn't need one, not really so much. Occasionally might need it, but you don't really need it in the same way as a mediator. And coupled with that skill of a mediator, you often need enormous amounts of patience. You have to give the parties space. You have to give the parties, even when sometimes you want to throttle them or hit them around the head. You have to be patient to let them move things forward themselves, while at the same time helping them and persuading them and moving them forward. So it's not simply a matter of sitting there passively while the parties don't do anything. It is a bit more active than that, but it's not as active as an arbitrator. Does that answer your question?
Thank you, Mr. Ben. I definitely agree to that, especially when you said we should develop the skill of listening, or the administrative skill, or the deciding fairly. All those sort of skills which has to be developed during the course of starting media practice, and the skill of having a great patience, especially to become a very good mediator. I definitely agree to that. I think I should develop certain qualities. I definitely agree to that. Thank you, Mr. Ben. And in line with it, Dr. Christopher To, I just have one small question to you. Sir, Dr. Christopher To?
I'm here.
Yes, in line to that, I just have one question to you, because this is, we already had a discussion of the question which I'm about to ask. The question is like, it's almost the same since you are one of the globally celebrating mediator. And I just have the same question, like what are the qualities you in your experience or in your expectation, you will tell that a student or an media practitioner should possess or should develop such skill? Can you just please highlight on that part?
I think being a mediator, one thing you have to have is good listening skills. You have to be patient. You have to be able to rephrase negative words into more neutral words. And without doubt, you have to understand how people react when you say something. End of the day, it's all about interpersonal skills, how you actually click with your client, and the client will trust you and open up and tell your inner secrets. So in a way, it's not magic, but give it time, give it practice. I believe that anyone can be a good mediator. So does that answer your question?
Yes, doctor, definitely that answers the question. But in line with that, I just move on to the next question on relying on this Singapore Convention, which makes this mediation agreement and sort of the total enforceability. But it is not the practical scenario as of in India. So can you just answer to this question, especially there are some audiences asked, this question is asked by so many participants here, that if there is a mediation agreement in India, then how do you enforce in India when one of the party not complying with the mediation agreement?
I think you have basically, India has not signed or rectified the Singapore Mediation Convention. So maybe this is something that your government might want to do. But in saying that, if one party has breached, say, the mediation settlement agreement, the only way you can take action is you just have to go back and sue them in litigation. Now, that's one way of doing it. The other way of doing it is you can actually go back to that party and ask that party, hey, you have not honored your obligations under the settlement agreement. Is there a problem? Can we now focus on the settlement agreement? Or is there something that there is a stumbling block that you cannot focus on? And if they agree there's a stumbling block or there's a certain change since the mediation settlement agreement was drafted, then maybe you can try to accommodate it so they can actually honor their obligations under the settlement agreement. So does that answer your question?
Yes, yes, doctor, definitely that answers the question. I totally agree to that, to be very fair. And in answering to the, yes, So answering to the one of the audience question. Yeah. Mr. Muthupandi Ganesan, I have one small question from the audience. Yeah. Yes, sir. Yeah, the question is, sir, and sticking on to the topic of this emergence of Med-Arb and covering to the part of virtual mediation, especially virtual area mechanisms, especially during this pandemic, could you give me the relevance or comparison between what is happening in UK and somewhat relevant to India? I hope you could give some aspect in what is happening actually in UK.
Yes, thank you for that, Samad. Yeah, in terms of, as I mentioned during my presentation, I have been involved in a number of online mediations and arbitrations that have happened on using online media. And we have had, in some cases, a mix of starting off with Zoom, things haven't worked out because you're not able to listen, or audio problems or video problems. Then we have switched over to WhatsApp, and more recently where you can see images of the people they're involved in, but we couldn't hear them. So we have had use of Zoom, Skype, and in some instances phone calls to conduct the actual hearings. I must say, any hearings where there hasn't been a video, what I mean by that is audio hearings and audio submissions or evidence, that's been very, very difficult. That's been very hard to do. But I think from a practitioner's point of view, a lot of effort is being made to try and progress cases and try and move cases onto online platform and do the best we can if possible. And there are some cases just simply not possible because the witness is not available, the technical problems, confidentiality, all the range of different issues. But from a practical point of view, there has been a number of cases we've been able to get through and haven't been just pushed onto the long grass saying, well, we will deal with it once the pandemic is over. And I think from a mediation point of view, I think it goes back to what Dr. To started off right at the beginning. People want resolution now. People do not want to wait 2 years down the line after pandemic for an award or a judgment in a litigation point of view, or a decision or resolving it. So from a UK point of view, certainly that's my experience. I think Mr. Giaretta may have different viewpoint from his practice, but certainly mine has been one of positive rather than negative. But going back to the Indian aspect of it, being a practicing Indian advocate as well, and that's been very interesting because a lot of our hearings, as we all know, has now become online. And in fact, I've been monitoring a case in the High Court in Delhi today whilst doing this. So that's been a real revolution in Indian circles, bearing in mind, as many of us know, India doesn't have any of the court hearings normally either recorded or transcribed. So this pandemic and the online revolution has been amazing from an Indian perspective, and certainly from access to justice, access to getting cases heard and moved, whether it's mediation or an arbitration, that has been amazing. So from a practitioner's point of view, I've been very positively impressed with the way that parties and advocates and lawyers, whether solicitors or barristers, have gone about trying to move cases forward, and that's been a very refreshing way that's happened. I think if somebody said to me, pre-February 2020, what do you think about getting cases heard using Skype or Zoom or phone calls, I would have said, well, most unlikely, people just wouldn't be interested in a voluntary sense. But now I think, as Dr. To was saying early on, clients are saying actually these online platforms are very effective, very useful, cost effective, and achieve things in a given time. So it's been positive, certainly from my respect.
Thank you, sir. And thank you so much for giving such relevance in comparing with UK. And just subordinate question to that, do you think, sir, UK is ahead of area mechanisms, especially governing the clause of both Med-Arb or Arb-Med or Med-Arb-Med? No, UK. You think UK is ahead of India in merging this and using of this clause? Just your perspective on that, sir.
Yeah, and I think certainly, I'm sure Ben and others will agree, the UK and England and Wales has been at the forefront of ADR for a long time, and it's well recognized, it's well respected and enforced by the courts, particularly in forcing parties to consider mediation. And there are a number of areas of law in England and Wales where mediation is essential before the courts get into a full-blown litigation. And similarly, arbitration is well respected and well recognized. But I think from an Indian point of view, I think it's very interesting times at the moment, particularly with the Singapore Convention on Mediation. As I understand, from an Indian perspective, India is very keen on that. And to my understanding, they have set up a special committee to look at to see how that Singapore Convention on Mediation can be ratified into law in India. And I think that's really important. And I know there has been Bar Council of India release and statements on making sure, particularly students and at universities such as Sathyabama, where mediation is to be taught as a core subject. And I think that's where the real exciting thing in terms of India is in driving mediation as a real tool, not only for clients and practitioners, but also for the future. And the future is, of course, students like you are, and many of you who's joined us. And I think that's where really the exciting aspect of how India is going to deal with Singapore Convention on Mediation and how it's going to bring it into the law in India. Whereas in UK, we are used to that, and there's a lot of emphasis on mediation in many different areas. And interestingly, just many of the students may find it of interesting fact. In the UK, where we have a National Health Service, we don't have a huge private medical care system, and there's a lot of emphasis now on resolving disputes between patients and doctors using mediation rather than litigation or arbitration as it used to be. There's a lot of emphasis on NHS, or National Health Service mediation. So yeah, mediation is, even in the UK, it's finding new areas of relevance, whereas in India, of course, it's a whole new ballgame and a whole new exciting ballgame.
Thank you, sir. Since we have almost the globally celebrating area practitioners from most parts of the world, from India, like we have Mr. V.Inbavijayan. In line to that, what Mr. Muthupandi Ganesan has given us, enlightened us, can you just speak on to the same point on the relevance of this mechanism, or how far this area is heading comparing to a litigation, or the scope of it?
Thank you, Shanmurthy. It was really hearing a lot of information about mediations from Far East to the West. That is the thing I could have it from Christopher To, then Ramesh Selvaraj, and my friend Muthupandi Ganesan, and my colleague in Chartered Institute of Arbitrator, Ben. Wherever we go or wherever we are going to practice, obviously this particular mechanism, that is, which has been considered as an alternative dispute resolution, whether it is mediation or arbitration, now is taking the stage of authorized dispute resolution. That is what I feel in the Indian perspective. Having said that, when you are looking into the growth of mediation as an Indian practitioner, 2019 was an excellent year. Couple of judgments in the Apex Court, the Honorable Supreme Court suggested to have mediation in motor accident cases, particularly the insurance sector, and second, in a historical dispute, that is Babri Masjid Ayodhya land dispute. In these two, one was in March 2019 and another was in July 2019. The Honorable Supreme Court of India recommended that we need to have an Indian Arbitration Act. That is very interesting. We need to have an Indian Arbitration Act. And following to that, India was initially very keen to just join with the UNISA, that is the United Nations Convention on International Settlement Agreement, which hopefully in coming months or year we might ratify, and we will bring out the mediation law. Simultaneously, we had this conciliation as a concept, which is quite popular based on the unsettled conciliation rules. I think quite earlier we had, along with the model law on arbitration, the conciliation rules also were very prominent. And India was the first taker, initial taker, to bring in conciliation as a part of arbitration legislation. In my limited experience in ADR, India has this peculiar inclusion of mediation in the form of conciliation in the Act. But this conciliation has obviously penetrated into the concept of not a facilitating process, but a evaluative process. That is the major change from the mediation, what the Indian conciliation had. And now, interestingly, the takeaway, that is the UNISA, the Singapore Convention on Mediation, is pulling back India from conciliation to mediation. That is the beginning stage for the Indian jurisdiction to consider this mediation concept along with the conciliation. And once we are going to ratify, I think very interestingly, when Christopher To was highlighting about the Indian jurisdiction, India is yet to ratify, but they are in the verge. It is very interesting to hear that Belarus, a country which is in a political uncertainty now, has ratified this convention, UNISA. And when we just go beyond in the Middle East, the Kingdom of Saudi Arabia, interestingly, has ratified this UNISA convention. Look into the jurisdiction which are accepting this concept. The Kingdom of Saudi Arabia, traditionally, which has its own indigenous system of resolving the dispute when it comes to outside the court, now has recognized. Then Belarus, which has a political uncertainty, I think if I'm right, Mr. Christopher To or Mr. Den or Mr. Muthupandi can correct me if I'm not wrong. Fiji, Qatar. Qatar is another nation which also has ratified this convention along with the parent country, that is Singapore. If you look on all these jurisdictions, predominantly these jurisdictions are focused on the Asian side. And Asia, being the major player now on the economic front also, is likely seriously considering to take mediation to resolve the disputes so that we can reasonably give a solution for the docket explosion what we are facing. All the Asian countries, whether it is the Far East or the Middle East or the South East or South Asia, we are having that issue of docket explosion, and the courts are not in a situation to manage all the litigation in a single-handed. And this mediation, as rightly pointed out by earlier speakers, the patience of that mediator, the perseverance of that mediator, the quality of facilitation of that mediator would eventually bring that restorative justice, which is very much required for the society. And I think India also is on the right path. Hopefully, in the coming years, India also would be the best platform to deal with mediation along with arbitration, because arbitration is the core area, as rightly Mr. Christopher To has started his career in arbitration at the Hong Kong International Arbitration Center, and the way how he just changed to mediation. And I could see a couple of friends from Chartered Institute of Arbitrator, Mr. Muthupandi Ganesan and Ben, along with Ramesh, the young SIAC co-chair, all we are interested to take this hybrid mechanism. Still, we need to have arbitration. Arbitrations are there to deal with some interesting component about the disputes. And mediation is the lighter part, wherein the parties are going to get the benefit, the win-win situation at the earliest point. That's what we feel. And arbitration, even though it is outside the ADR, outside the court mechanisms, still it is somewhat adversarial. At least in the Indian perspective, we feel that it is all presided by the former judicial authorities. It is all facilitated by the same process, what's happening in the courts. Like we do have the examination. Literally, I had a cross-examination which underwent for more than 2.5 hours. Just one witness was examined, and that too, that witness was an expert witness. In India, we are having this expert witnesses also as a normal. The court process is going on. It's taking its own time. Along with this, if you are going to bring mediation, then I think it has a bright and a good future in India also.
Thank you, sir. Thank you. That was really guiding and it was very informative. Thank you, sir. So in line with that, I have one question. I guess there is nothing to add more by the panelists, Mr. Muthupandi Ganesan, sir, Ben, or Mr. Ben, or Dr. Christopher To. Is there anything to add what Mr. V.Inbavijayan has said?
Nothing for me.
Okay. I'll just shoot on the next question, sir. If you take the practical scenario in India, where we don't have that much influence of the Singapore Convention on comparing relatively with the signatory parties of the Singapore Convention, where the practical sense of the practical scenario here is that it is more of a court-annexed mediations. And on that relaying, can you just please give a brief about what is the scenario in Hong Kong, or how far India has to develop in this particular scenario?
Yeah, I think Christopher, can you just share with us the court-annexed mediation, if you want to say anything in Hong Kong?
In Hong Kong, we don't really have so much court-annexed mediation per se. We tend to actually, the judges tend to actually encourage people to do mediation, because if they don't do mediation, what will happen is the case goes back to the judge, and the judge will ask, how come you didn't settle mediation and so forth. But we do have a program now whereby everything to do with small claims, anything to do with, say, we're talking about roughly £5,000 and below, anything to do with that, then what will happen is the judge or the tribunal and the small claims officer will basically say to you, you should try mediation in an organization called the Joint Mediation Helpline, and you should try it out. The success rate so far, I gather from last month's statistics, was roughly about 78% success rate in terms of settlement. So in a way, we don't really have court annex mediation per se, but we do have very sort of supportive judges like in UK who encourage people to use mediation. So does that answer your question?
Yes, completely, doctor. I think we have and we are in the verge of ending this panel discussion. So thank you, Mr. Muthupandi Ganesan. Thank you, Mr. V.Inbavijayan, and thank you, Dr. Christopher To. Thank you, Mr. Ben, for such a wonderful panel discussion. I think we have almost covered all the aspects, and both in the subject as well as in the geographical aspect. I think it's time I should hand over to the host to hand over for the next session. Yeah, thank you all.
Thank you, Mr. Shanmugade. Now, I call upon Ms. Ashwita, BBA LLB Honors third year, to introduce Ms. Rekha Rangachari, Executive Director of New York International Arbitration Center.
Thank you, Ishwa. Warm welcome to everyone present here. It is indeed a great honor for me to welcome and introduce our guest speaker, Ms. Rekha Rangachari, who is presently serving as the Executive Director of the New York International Arbitration Center. And also, ma'am serves as the Chair of the Arbitration Subcommittee of the New York City Bar's Inter-American Affairs Committee. Ma'am is board member of Arbitral Women and the Association for Conflict Resolution of Greater New York, and also co-chair of the private international law interest group at the American Society of International Law. Ma'am also maintains an active connection to an academics as associate editor of the Juris Investment Arbitration Conference volumes and adjunct professor of Seton Hall Law School. Having such years of expertise and specialization in arbitration with us. Once again, on behalf of School of Law, Sathyabama Institute of Science and Technology, I extend my warm welcome to you, ma'am.
Thank you so much. Delighted to be here.
Thank you, Ms. Ashwita. I now request Ms. Samyukta, Student Coordinator from Second Year BCom LLB Honors, to introduce our speaker, Dr. Kabir Dugal, Arbitrator, Attorney in New York Office of Arnold and Porter, and Lecturer in Law at Columbia Law School. Over to you, Ms. Samyukta.
Thank you. The expert in anything was once a beginner. Good evening to one and all present here. We, School of Law, Sathyabama Institute of Science and Technology, takes immense pleasure in inviting Dr. Kabir Dugal, Arbitrator, Attorney in the New York Office of Arnold and Porter. Dr. Kabir Dugal is an Senior International Arbitration Advisor in New York Office of Arnold and Porter. He is a lecturer in law at Columbia Law School. Sir is Managing Editor in American Review of International Arbitration, Course Director and Faculty Member for Columbia Law School's Chartered Institute of Arbitrators Comprehensive Course on International Arbitration. We, School of Law, Sathyabama Institute of Science and Technology, wholeheartedly welcome you, sir.
Fantastic, thank you. Let me just echo what Rekha said. We're delighted to be with all of you. We would much rather have preferred being there in person, but one of the advantages of technology is that you can have speakers from all around the world connecting, so we are delighted to do that. If I may also just make one side observation, you know, in the US right now, we consider an event to be a success if 30 people show up. I think it is a tribute to India, it is a tribute to KF, to all of you, you know, at the organizers, to V.Inbavijayan, to Shanmuga, that, you know, you all take this number 10 times higher than what we are used to. Shanmuga, yes, we will be grateful if you could get the slide deck up. I'm happy to share my screen if that works too. If you give me magical powers, or you can share the screen.
I request Ms. Rekha Rangachari, Executive Director of the New York International Arbitration Center, and Dr. Kabir Dugal, Senior International Arbitration Advisor in the New York Office of Arnold and Porter, to preside over the session on the topic, the impact of COVID on investor-state disputes and how Med-Arb may be practical way to resolve disputes.
Fantastic. Let me pass the floor to Rekha because you will get to hear all the intelligence from Rekha. I am here largely for beauty value. So Rekha, with that.
I thought I was here for that. In any case, as Kabir said, we really are delighted to be here with you. It is such an amazing following and audience, and really our kudos to the organizers for putting together this panel, and to our previous speakers as well. So I think they've set a very high bar. We will try to meet it best we can in our time. We're talking today about Med-Arb, something generally that we conceive of in Asia as being palatable. Med-Arb is a funny thing as we look to common law jurisdictions and even the US. Lots of discussion about what are protocols in place to safeguard it. Can the mediator really engage in settlement negotiations and then become an arbitrator? How does that work? What is the rubric? And so we're going to posit to you some questions as we go along. We hope it's interactive, and so we hope you use the chat function to talk to us, to pose questions, to have a conversation. And with that, we'll jump right in. And the other thing I guess we were going to say is it's really delightful in these one good of pandemic, right, is that we have been able to engage seamlessly in cross-border dialogues. We used to do it, but much more cognizant of time in one jurisdiction against another. These days, I feel everyone is so flexible that they're able to just comport, and we really get to have a fluid discussion. When we talk Med-Arb, that becomes really important, even more so as we talk Med-Arb and its relevance in investor-state disputes is a much smaller niche. So please share your perspectives on that in the chat, so it's not just us talking at you. Kabir, the mic pass goes back to you.
Sure, Rekha, let me just start off by asking you the first question. You know, we're now looking at the future, right? That's the topic as you see on the slide. But before we look at the future, let's do a little bit of stock taking of how things happen in investor-state arbitration today. Now, we're going to use the word BC, and we don't mean this in any very historical sense. You know, it's not the BCAD. BC for us means before COVID. So, Rekha, how did arbitration, investor-state arbitration in particular, happen before COVID? Shanmuga, could we move to the next slide? Once more. Once more.
There are lots of bullets here, yeah.
And once more.
Perfect. So arbitration process, as you know it, this is what it was. And let's underscore, this is true if you were in investor state or you were in commercial arbitration, right? Lots of paper, lots of travel, lots of motions, and elongated timelines, right? It is common to ask for to make the request to extend a deadline, and usually, absent objection, it would be extended. Not necessarily always for issuance of the award, but at least as we build that towards that, lots of extensions. So, you know, a word that has become commonplace in our discussions is efficiency, transparency, cost effectiveness. Are we getting there in pandemic becomes the overlying question, but let's not forget, because the fear is that post-COVID, we will go back to these bad habits that we already had. Kabir, weigh in a bit, maybe with your counsel perspective.
Sure, totally, Rekha, thank you. You know, both Rekha and I serve on the Green Pledge for Arbitration, which is an initiative to try and reduce our reliance on paper. And there's a very troubling statistic that comes out that a mid to small size arbitration, just hear the words, mid to small size arbitration involves cutting of 20,000 trees. Now, this is how we have been doing things, right? We typically printed everything, we shipped everything, we traveled to a location. All that has an implication for the environment. It has an implication on your pockets. That's something to think about, right? We had lots of motions practice, right? Everybody tended to lose. Well, I should take that back. Everybody tended to win, potentially not your client who has to pay the money and follow the process of this long, drawn-out affair, right? So let's just keep this as a high-level perspective in the back of our mind as we are looking about how we did things. With that, Shanmuga, could we move to the next slide? Okay, so with COVID, what has changed? Okay, Rekha, do you want to start off with maybe the first 2 points and then I'll take the next two? Sure. We're trying to make this a dialogue and trying to get everyone warmed up and join us. We're having a tea and coffee, so we are energized.
Well, so these are things you know, right? But again, sometimes the obvious is important to highlight. Access to justice has often been a conversation, especially when we talk about cost, when parties have to travel to have their hearings, either in a venue that's at the seat or beyond the seat. And sometimes a seat is not always the most convenient place to go. And so it's not alone the travel costs, it's the travel costs, the room and board, everything else. And so this notion of access to justice comes at a cost, right? It tethers into, have we also become paranoid and the due process paranoia? But separate conversation. We will get to that. Stay tuned. So now, what has changed? Beyond this access to justice, more people can hop on, for example, a Zoom platform and have a hearing. They don't have to travel. And so witnesses also don't have to travel. They can stay where they are, wherever in the world they are, and often, and the experts as well. And so we're now limiting this geographic reach reality because they just need a secure connection. Truth is, the secure connection could pose a problem depending on the jurisdiction. But notwithstanding, we are getting perhaps towards best practices now, our best selves in arbitration in pandemic. Kabir, back to you.
Sure. Let me just step in. See, if we're talking about this in the investor state context, the respondent is a state, right? The respondent is a sovereign. To make this easy, let's just think. We're talking about India as being the respondent in the dispute, right? Now, it's easy for us to imagine a country as this, romanticized notion, but what is a country? A country is the people. If we're talking about India, we're talking about all of us. So when we're talking about an award, when we're talking about costs, who is bearing the costs? You all are bearing the costs, right? So if we're talking about travel, sure, the arbitrators are going to fly business class, they're going to stay at a fancy hotel, the hearing's going to go on for 3 weeks, they're going to be 6 years of proceedings. There is a cost, and the cost is being borne by the public. So let's just keep that in mind when we're talking. One benefit that we're seeing is, things are moving virtual, and therefore travel has reduced, the opportunity of people who were not represented getting an avenue through access is improved. Things like this are possible. We're in New York. Y'all are all over the world, but I would assume a lot of you are in India. We're able to facilitate dialogues like this. We're able to facilitate hearings like this, and that's a plus. In some senses, technology is taking us apart. In some senses, it's bringing us together, right? And to that extent, we are seeing it could be more efficient, it could be flexible, it can create greater accessibility. There are advantages that we shouldn't ignore. This is not to suggest everything is perfect. Obviously, things are not perfect in any given scenario. And that's what we're going to talk about. If things are moving virtual, what might be some of the challenges we see? Shanmuga, may I request you to use your magical powers and move to the next slide. Once more. Rekha, should we do the same thing? You want to take the first two, I'll take the next two.
Perfect. So witness coaching has become something that is of top concern. Many companies that are assisting in the platform are now shipping out 365-degree cameras. This notion that they will have the witness scroll around so that they can demonstrate and confirm nobody is in the room, both at the start and the end. And if there are any concerns throughout, there's that feed running that somebody else can be monitoring. Does that accomplish any issues with that? Who knows, right? But there's a lot more time being invested in technology and securing the witness. Next, this notion that I raised already. While we've been able to get greater access, right, to justice, we can only do that if there's a stable internet connection. And while many countries have that, inconsistency of a signal becomes a really big concern if in the middle of testimony, something happens and the line gets cut. I highlight here the SOL protocol that you may be familiar with, amongst others, under the KSAB rules. And it delineates specific technical requirements so that you can ensure, parties can ensure they're all on the same page about what it means to run an efficient hearing. Also, the African Arbitration Academy provides a set of protocols about virtual hearings. What do you need in terms of network security, audio and video encryption? What should it be? It says 128 bits, for example. And I share these only to say these are two examples amidst many that give us guidance and start to concretize What do we need if we go virtual? There's a lot of other protocols out there, including now draft protocols for procedural orders, specifically designed for virtual. With that, Kabir, please weigh in on the final 2 points.
Fantastic. Thank you, Rekha. Shanmuga, may I request you to do one more hit, just one more enter on the mouse? Awesome. Now, this is something that a lot of you may recall when Zoom had just started. If I am not mistaken, I could be wrong about this because I read this some time ago, but I think it was in Tamil Nadu. Now, I'm very anxious to say this because I'm in a room where I know there are folks from Tamil Nadu, and if I get this wrong, it's very embarrassing. But I believe there was the time when Tamil Nadu had actually prohibited the use of Zoom for official business because of technological concerns, right? And the biggest instance, and this had actually started in US universities, was Zoom bombing. That is, somebody hacks into your presentation, and while you can now see our amazing GIFs on the screen, suddenly somebody took that down and put pornography up. Now, Rekha and I actually remember a very famous arbitrator telling us this, that, look, prominent people, really smart people. She was conducting an arbitration and somebody started this, Zoom bombing. And when the pornography came up, you freeze and you don't know what to do. She said her immediate reaction was to shut her laptop, right? Now, that's obviously not a solution, but I think the point we're trying to make is technology can be hacked. So can we create a secure platform? Because one of the concerns about arbitration, or one of the first principles, is confidentiality, right? And the final point, I just want to underscore this, is due process. You want to make sure everybody's getting an equal opportunity to be heard, right? Now, let's think of a situation. We have a party in Australia. We have a party in India. One of your arbitrators is in Europe. The other is in America, and one is in Latin America, right? So we have covered the entire world, and I've given a fairly accurate example, right? All the arbitrators tend to be from North. The parties tend to be from anywhere in the world, and that is a deeply problematic thing, but that is the reality we find ourselves in. Now, if you're looking at this time zone, either your hearings are going to be 3 hours every day, right, to accommodate the time zones, or somebody is going to, I mean this in the nicest way, somebody is going to really have to suck it up and just stay up at a weird hour, right? That's not ideal, right? If you're going to be giving testimony and you're told, for you, it's 2 o'clock in the morning, and you're like, here's my coffee. It's not ideal. So there are due process concerns. Let's just keep this framework because we are accepting the pros and cons of a virtual reality. Let's move a little bit into investor state to look at now some of the impacts we're seeing of COVID before we jump into Med-Arb. And Rekha, let me pass the floor back to you. Perhaps you can tell us what happened before US courts when it came to enforcement of decisions. Shall we talk a little bit about the famous Bolivia case?
Yes. And our hope is that...
Sorry, forgive me, Rekha.
No, perfect. Perfect. Our hope here is to give you a few snapshots to add color to what we're talking about, right? To encourage dialogue. So this is an example. It's a recent ISDS case under the auspices of the PCA. It's dealing with mining concessions under the US-Bolivia BIT. And so Bolivia ends up asking for an extension to submit its statement of defense. It says pandemic has made the work very difficult, or in their own words, virtually impossible. It uses arguments of force majeure and frustration of purpose. Specifically, the Bolivian team cites to global disruption, we all know this, and as well the Morales regime and the resignation in November. How did that disrupt the political reality and the rule of law? They cited as well to US disruption during pandemic, trying to take broad strokes here about what disruption means in the global marketplace. In truth, as we all know it, force majeure, very high standard to prove. In reply, claimant comes back and they say Bolivia fails to prove that standard. And they failed to prove specifically that the spread of COVID-19 was unforeseeable. This is one of the elements, right, of force majeure. That filing written submissions is feasible, actually, in spite of pandemic, because we can do this remotely. And so it comes to this notion of how does advocacy look in pandemic? Do we have to try to go for those high standards like force majeure? Or rather, is it better off in terms of advocacy to instead pivot and argue towards the tribunal's humanity? And so in contrast, I give you an example of a recent case, also ISDS, but not so public, where counsel in New York argued, listen, I'm at home with 4 children. It's very difficult to meet this deadline, and absent objection, it would be great if we're able to extend it. No issue extending the deadline. And so it goes to how do we operate not only as people, but also as lawyers? Do we have to go for the high bar? Think about this constantly, because force majeure becomes one of those terms, I think, in pandemic that we have been throwing around a lot. What has been interesting is that it ends up being more of a theoretic conversation, because as we know as well, force majeure is very specific application of the facts and really depends on a case-by-case basis. With that, I'm going to turn over the floor to Kabir to take us through some of the reasoning of the tribunal.
Fantastic. Shanmuga, again, I'll use your magical powers to move to the next slide once more. Thank you. So as Rekha says, here you have a party that's coming out and saying, we can't go forward, and the reason being given is COVID, right? Rekha gave us all the reasons, and this is the issue before a tribunal, right? Now, as Rekha also mentioned, this is happening early in the pandemic. This is happening March, April. The pandemic is, I know it seems like a lifetime. It really does. But this is when the pandemic was really picking up, right? The matter comes before the tribunal, and I'd urge you all to think about, if you were the tribunal, what would you do? And the tribunal's reasoning, I think Rekha hinted at this, in light of the arguments of the party probably was, look, COVID is terrible. COVID is really affecting all our lives. For arbitration, it's presenting a lot of challenges, but we can adjust. And that is sort of what the tribunal tells them. We hear you, we feel for you, but pandemic is not going to shut down our life. You can move virtually. And we're going to encourage you to move forward virtually. What is the key takeaway from this? The key takeaway from this is that the tribunal was not persuaded that COVID in and of itself was going to end things, right? So just keep this in the backdrop. Obviously, there is no precedence in investor state or in international arbitration, but this is some indication, at least from what we know, about how tribunals have looked at the issue. So let's keep this one case, and we'll now very quickly just thumb through some other potential cases arising out of state action. That is, states have taken actions under COVID, and you're having investors coming forth and threatening investor-state arbitration. Think about this in the Indian context. We're not giving an Indian example, but we're giving other examples that have come up. Rekha, do you want to tell us what's happening in Peru?
Sure, and I guess also it's important to say you all are the experts in India, so in no way did we want to come into your house and tell you what's happening in India. Rather, we would like to hear it from you. But we take these snapshots, and what we want you to keep considering is how the tribunals are evaluating, for example, a party's unwillingness to adapt, to pivot in light of COVID, which very much in the Bolivian example, because of their pleading towards force majeure, the tribunal kept them to that high bar and said, you need to pivot. You need to be transformational and innovative in these times. Okay, Bolivian example to the side, on to Peru. So in the Peru case, do we have the slide up? Yeah, okay. You may have heard of this, right? Strange things happening in pandemic all over the world. And so now, beyond just safety concerns, human safety concerns, this notion of emergency measures in Peru, they suspend the collection of tolls. In the first week of April 2020, several concessionaires manage the tolls across the country. Peru has a lot of a lot of territory to cover. So this becomes important. 74 toll roads in Peru, 24 run by state-owned companies. 32 operators agree to voluntarily stop collecting tolls, leaving about 18 operators, right? Dealing a unilateral change in government, saying no more collection of tolls, and dealing with changes in their contract, dealing with changes in state action and what that means in times of crisis. The gloss is always, we're in times of crisis, right? Note also that during this time in Peru, there were two different states of emergency that were going on. The health emergency, obviously, right? And then national emergency. And so lots of chaos happening. How does a business continue to run, right? How does a businessman who's in the business of collecting tolls continue forward when you have this sort of abatement reality? And it's not a new thing for Peru. You'll see also Peru has been in the news, right? Facing claims from Spanish investors, its Pan-American highway. The scale of impact is really important. In pandemic, at that point, some time back, it was something like 5,000 cases of coronavirus and over 150, 200 deaths. And so it becomes a really big issue of how do investors deal? What are they supposed to do and what is their recourse? Where does due process exist when the rule of law itself is unstable? Kabir, I will pass the mic back to you.
Fantastic. Let me just give another example, Shanmuga. Thank you. You got into the groove now. We don't need to tell you. I'll just give another example. You know, here we're seeing Mexico, and an example we're seeing with Mexico. The point we want to highlight is every time a government does a regulation that impacts business, there could be a potential ISDS claim. You may or may not prevail, but the investor can bring a case. Now, Mexico, in light of COVID, now I use these words in quotes because the investors dispute that, it started putting restrictions on renewable energy, right? And the reason was because of COVID, the demand for renewable energies has reduced. The investor's position is, no, you didn't like us from the beginning. COVID was a pretext. And you can very easily see both sides of the argument. So all the renewable companies in Mexico are getting ready to bring potential cases, right? Now, I'm not going to delve further into detail in the interest of time, but just the idea here, looking at Peru, looking at Mexico, we're seeing threatened claims in Italy, in other cases in LATAM, right? You're seeing this idea that changes are going to result in claims. At the same time, we're seeing a call to stop investor-state arbitration, right? We're seeing a call for a moratorium. Shanmuga, can we move to the next slide? And let me just put this to Rekha. Rekha, can you tell us a little bit about this moratorium? Because I think that is the crisis we are trying to address and look at Med-Arb.
Right, and so this is this moratorium notion, right, within ISDS. It's a hard stop on claims filed by investors in periods of emergency. It's calling investors to say, this is not the right time, right? But the backfall is, what do you do? Will you get time barred if you really honor this sort of moratorium hard stop? When will it end? This becomes a much larger issue because as people, we all are, I think, in our own ways, looking for a deadline. When will pandemic end? We haven't been given one. Now, across jurisdictions, we are seeing the second wave, the second uptick of cases. And so it really becomes ambiguous. And in law, we don't operate in ambiguity well. We don't advise our clients well in ambiguity either. So how do you deal with this gray space? Is it working? Time will tell. The truth is that if you look at filings overall across both the World Bank, the PCA, and commercial arbitral institutions, filings overall are up. So whether the moratorium and call to action on May 6th is working, I query you to look at the filings you're seeing in region. I would argue we're seeing, in general, an uptick in these times, although the curiosity will remain. can the parties pay whatever fees will be asked for, both of their counsel and from the tribunal at the end of the day. Kabir, back to you with that.
Fantastic. Let's move on to the next slide, Shanmuga. Let me just pick up from where Rekha left it off. They're calling this very prominent body associated with Columbia Law School is calling for a stop for arbitration. They give many reasons, but the critical point they're saying is that when you have a crisis, a state's focus should be on health of people, not distractions on cases, right? This is one reason that they're giving, that, budgets now should be used for the health and well-being of people. It should not be used for cases, right? This is a major call, and this body is going out trying to get government consensus to implement this moratorium. Remember, investment arbitration exists because states agree. If they don't agree, it can end. And this takes us, Shanmuga, could we move to the next slide? Awesome. This takes us to our current proposal, okay? Could we potentially be looking, in the light of this crisis, at Med-Arb as a potential compromise, right? Arbitration, as we just heard V.Inbavijayan speak in the prior intervention, arbitration tends to be adversarial, right? One party wins, one party loses, right? It tends to be long and drawn out. Could we potentially look at mediation as a potential avenue to address some of these concerns? Now, let me just point out that mediation in investor-state arbitration has been grossly underutilized, right? Most treaties and your obligations for investment arbitration arise out of treaties, right? Most treaties have like a 6-month cooling off period that governments essentially all over the world, this is a consistent pattern, don't utilize. It is just time that the governments use doing nothing. I mean this in a nice word, they may call the investor in, but it's never utilized. In the light of the Singapore Convention that we have heard our prior speakers talk about, in light of the fact that very often mediation could be an effective avenue to resolve disputes in a more amicable manner, in a quick manner, you don't have to have all the motions practiced, you don't have to have hearings for 20 days, right? Could we be potentially changing the way we think about things to give mediation a chance, right? The Singapore Convention now gives us a framework, right? That's a positive thing, as you have heard all our prior speakers very eloquently talk about. Could we use that to address some of these concerns? That is the question we posit. Rekha, I know we're running short of time. I think we're probably already almost at time. May I just propose, rather than us doing the next 2 slides, which you can all take, Shanmuga, feel free to send it to people who are interested, I wonder if we just jump to the slide towards the very end, where Rekha can talk to us and tell us, what do you think the future might look like, both for Med-Arb and for the crisis in investor-state arbitration for virtual hearings? So Shanmuga, we're going, oh, wow, you have supernatural abilities. You figured it out. Good for you. Rekha, do you want to tell us what is the future going to look like?
The answer may not be so satisfactory, in that the truth is we just don't know. I will say, as you all know, arbitral institutions across the world have pivoted, and they're offering these protocols, these procedures, go virtual. The truth is that the rules within most arbitral institutions always allowed for us to go virtual a long time ago. It's just that we never felt the need to do it. And so now, if we're going to do it, what does that entail? Right? There are so many resources, and to be honest with you, part of the difficulty is figuring out where to go. But I urge you, go to your preferred institution and look there first. As I mentioned before, protocols on procedural orders, if you are an arbitrator, protocols also for parties to consider if they're doing joint submissions, including even protocols about entry and egress to a hearing venue, which NIAC is a hearing venue. I have been amazed at what I've found online. And the other reality is parties are learning. One thing I'll direct you to, and I'll post it in the chat in a moment, is we're now also engaging in a discussion, ICA has launched it, about do parties have a right to an in-person hearing? Are there due process concerns, or rather the increasing due process paranoia? Shouldn't we be able to just do it better in virtual? And it's a big open question. I invite you to study the survey as they're doing it with ICA. But Kabir, what are you seeing as counsel practice, as arbitrator in practice? How adaptable are the parties and the tribunal?
I mean, Rick, I think that's such a great question. You know, I think it's a mixed bag. You know, we definitely, especially if we're talking about the future, you know, I think right now we're all making peace. This is what we have to do. For the future, things are a mixed bag. You know, I think my own prediction, I'm very, very scared to say this because I've been wrong about some of these things, is we will likely see a greater acceptance for small to mid-sized disputes. I think that's a good thing. I think if you're talking about large, complex disputes with parties from all over the world, we may likely see a hybrid in-person model. Whether it's going to be entirely virtual, not sure about that, right? So that's sort of how I'm looking at it. I do think, you know, somebody has posited questions on gender. You know, I think Devi had put a question, and look, you know, internet or virtual hearings have the ability to create greater access. You know, underrepresented groups get this avenue. Having said that, you know, the study that I think Devi has put in the chat does also reflect the fact that you know, COVID has disproportionately affected women all over the world, right? So I just posit that while we are thinking about improving arbitration, we should also be thinking about how we address broader issues of representation, right? You know, people typically talk of arbitrators, you know, this term is slightly pejorative, but I think there's some truth to it, right? The male pale stale, right? Arbitrators tend to be from certain European countries of a certain age group. That's not good. That's not representative. We should be thinking about anything that we're doing. How do we make systems more representative? So I put this as a broader challenge for the students of university. We leave a lot of things to you to figure out: the environment, gender, equality, in addition to improving arbitration. No pressure, but you guys are up for the challenge. With that, Rekha, I think I have nothing further to say. I'm going to pass it back to you, and we could perhaps take questions, but you should give your final remarks.
No, well, I think, you know, picking up on the diversity point is an important one, right? As we keep talking about resilience in crisis, we need to also talk about advocacy. And what does it mean if we shift fully to virtual, where it's really just the lead counsel, one or two folks who do the oral argument? What happens to the whole host of team members that are no longer really visible to the tribunal, that don't get access in the same way? And we're seeing issues with diversity in truth. I posted within the chat the ICA report number 8. I realize a lot of my resources today are ICA, but a dearth of resources always. There's no dearth of resources. It's so many everywhere. And so ICA being one example. ICA report number 8 recently came out. And why I like this so much is because there have been so many conversations about how do we move the needle. I think it becomes very difficult to understand and concretize this. When you talk about it in vague terms, we all have a role. Frankly, the institutions came under fire initially to say, you all have to fix it, you deal with appointments. And they all responded, right? They said, actually, it's the users that have to fix the problem. It's the in-house counsel that have to deem it important if we're going to fix the diversity dividend challenge. The ICA report in specific has checklists. So depending on which stakeholder you are, and it applies to everyone, you're a practitioner, you're an arbitrator, you're a third-party counsel, you are an expert, everyone has a role to play. And these checklists allow you to identify who you are as a stakeholder within the IA community. And then there are options there. What can you do? I think this will get us towards a there more concretely than any other report I've seen. And so do take a look at that amongst others that you may already be consulting as a means in virtual, because we're going to be in it for some more time, realistically, as a means to get us there and to keep advocacy and diversity hand in hand. With that, I think we'll pause here, very conscious of time, and maybe take any questions that the audience has as we talk about what does Med-Arb, even Med-Arb Med, mean in pandemic, in addition to a whole host of other curiosities that you're all dealing with.
For everyone who's asking for the YouTube, it is going to be on the Kfcri website, So,
I see Imba smiling. Yes, we will.
Good.
Thank you, ma'am. Thank you, sir, for your thought-provoking session. And I also thank Mr. Shahrukh Kumar and Mr. Svetin, Managing Committee and member of Kfcri, for sharing the screen for this session and for the previous session and for this steady support. With the permission of the speakers, now the forum is open for Q&A session.
It can either mean two things. Everybody has understood everything totally. That's one. Or the other thing is this is the time when everyone needs dinner. It could be either.
Well, so we got a question here, right? In what way can Med-Arb be compromised? Well, I'll take this first, perhaps, Kabir, if you'll allow me, and then pass it back to you. So when we talk about how Med-Arb can be compromised, first, as we move to virtual, Med-Arb in ODR platforms can be difficult. How do we intuit language and what tonality means, right? Because sometimes there's a lot more imbued in words, and then misunderstandings can happen. That's one example that many mediators have shared, that sometimes in an ODR platform, it becomes difficult. Another curiosity of Med-Arb, as I highlighted, I think right at the beginning is, or Med-Arb Med, which is another sort of rubric that's coming out. Should the arbitrator be able to be one who can go back and do mediation? Should you have a separate individual, a mediator, who comes into the process if the parties realize there are certain perhaps insular issues that they could deal with a mediator off to the side, then come back to the main arbitration in chief? How do you sort of juxtapose this and conduct it well so due process is never an issue and so ultimately the award is never compromised? Another curiosity I want you to think about is when we talk about Med-Arb and Med in general, what sort of a mediator helps the process and what are the cultural implications of the Med process? Do you have a facilitative mediator, an evaluative mediator that really pushes towards a settlement agreement? And does all of this come out towards advocacy in virtual in a seamless way as it would in person? So lots of curiosities here to think through, actually really great topics to write papers on to the students, and Kabir and I are happy to help you with this if you're thinking about it, not only writing one, but where to publish it. So lots of things, but you know, as we look at ADR in general, it's not stagnant. And so when you have optionality, are too many options part of the problem? With that, Kabir, I'll turn it to you. Curiosities on the Med-Arb and issues therein.
I mean, I fully agree with everything you have said. Just one point, you know, with Med-Arb, if you're having them not happening concurrently, if you're having them happen sequentially, there is always the question, right? Is the state really going to settle or is it only going to delay things further? So I just posit that as a genuine concern that comes up. I think logistically there are issues to be worked out. I think the broader issue is, though, there are solutions to all of these things. I don't think any of these are problems that warrant mediation being discarded. We should be thinking about mediation more and thinking about it more thoughtfully. So I'll stop here in the interest of time.
Thank you, sir. Thank you, ma'am, for answering the question so patiently. I kindly request the participants to fill the feedback form, which will be provided at the end of the session. Over to you, Arvind.
Thank you, Vishwa. I now request the student coordinator, Ms. Pratima, from first year BBLLB Honors, to render the vote of thanks. Over to you, Ms. Pratima.
Thank you. A warm and graceful evening to our most valued speakers, Ms. Rekha Rangachari and Dr. Kabir Dugal. Ms. Rekha Rangachari is the Executive Director of the New York International Arbitration Center, Chair of the Arbitration Subcommittee of the New York City Bar's Inter-American Affairs Committee, and more. And Dr. Kabir Dugal is a Senior International Arbitration Advisor in the New York office of Arnold and Porter, Lecturer in Law at Columbia School, and so on. Never miss the opportunity to thank someone, because once a great man was paid, feeling thankfulness and not expressing it is like wrapping a gift and not giving it. So I kindly take this opportunity to thank you too for giving us a very informative speech and enriching our knowledge about the impact of COVID on investor-state disputes and how Med-Arb may be a practical way to resolve disputes. Also, thank you again for spending your precious time and being patient throughout the session. Indeed, your words have inspired the students and will always continue to do so. It's my privilege to propose a vote of thanks speech and acknowledge the contribution of those who have worked really hard to make this international conference happen to be a great memorable occasion. Thank you so much.
Thank you, Ms. Pratima. Gratitude can transform common days into Thanksgivings, turn jobs into joy, and change ordinary opportunities into blessings. Now, I humbly request the Organizing Secretary, Ms. Pooja Shri, Assistant Professor, School of Law, Sathyabama Institute of Science and Technology, to deliver the vote of thanks.
Thank you, Mr. Ishwa. The roots of all the goodness lie in the soil of appreciation for goodness. Good morning, good afternoon, and good evening to one and all who have joined with us today. Myself, Pooja Shri, have the pleasant task of delivering vote of thanks to this amazing gathering here. On behalf of School of Law, Sathyabama Institute of Science and Technology, in association with Kovise Foundation Conflict Resolution International, I extend you all a very hearty vote of thanks for gracing the International Seminar on Emerging Trends at Med-Arb, a grand success. I feel honored in thanking our management, Honorable Chancellor, Dr. Maria Zena Johnson, ma'am, and Honorable President, Dr. Mary Johnson, sir, and respected Vice Chancellor, Dr. Sathyabama, for granting us and giving us this wonderful opportunity to organize the successful event. Gratitude is not only the greatest of virtues, but the parent of all others. I deem it a great privilege in extending my sincere and deep sense of gratitude to Professor Dr. Sheikh, Dean School of Law, Sathyabama Institute of Science and Technology, for extending her enormous support and encouragement and carving a niche for School of Law in organizing several events in the various arenas and contemporary issues of law. Thank you so much, ma'am, and our School of Law owe to you extremely forever. At this juncture, I take this opportunity to extend my most sincere thanks to our knowledge partner, Mr. V.Inbavijayan, founder and project advisor of Kfcri, founder of Kovise Global LLP. Sir, I'm really in search of words to express my thankfulness to you in organizing this successful international event. And I also thank the energetic members from Kfcri for their swift and dynamic actions in organizing this event in a very short span. I would also like to extend my heartiest and deepest gratitude to all our key speakers of the day, Dr. Christopher To, Mr. Ramesh Selvaraj, Mr. Ben Giaretta, Mr. Muthupandi Ganesan, Ms. Rekha Rangachari, and Dr. Kabir Dugal for accepting our invitation and sharing their remarkable insights and valuable knowledge in the field of Med-Arb. I also extend my warm gratitude to all other faculty members and the dedicated student coordinators from Sathyabama School of Law who work tirelessly for the prosperity of this event. Last but not the least, I hardly find words to thank all the respected faculty participants, law students, and all other participants from across the globe without whom this event wouldn't have been this successful one, and also to have spent your valuable time and active participation, and also for your patience listening to us for the entire session. I cannot thank everyone enough for the involvement they have shown and the willingness they have expressed to take on the completion of the task beyond their comfort zones. Once again, on behalf of School of Law, Sathyabama Institute of Science and Technology, in association with Kovise Foundation, Conflict Resolution International, I wholeheartedly thank one and all who have gathered with us today in this virtual platform. Thank you.
Thank you, ma'am. I now request you all to raise your feet for the national anthem.
Over to you, Mr. Ishwa.
I now request you all to raise your feet for the national anthem.
Jana Mana Adhinayaka Jaya He Bharat Bhagya Vidhata Punjab Sindh Gujarat Maratha Dravida Utkala Vanga Vindhya Himachala Yamuna Ganga Uchchala Jaladhi Taranga तव शुभ नामे जागे तव शुभ आशीष मागे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
For the kind attention of the participants, the feedback link will be posted in the chat box. The participants are requested to submit it in order to receive the e-certificates. The feedback link will be open for another 15 minutes. Thank you.
Bye, everybody. Bye.
Bye. Bye.
Bye. Thank you so much.
Thank you very much. Bye-bye.
Thank you, sir. Thank you, everyone. Thank you.
Thank you, sir. Thank you, ma'am.
Thank you.
Thank you all.